Thank you, the Lordship. The Lordship, I beg to mention item number 8 and 13, your Lordship. Yesterday, I have submitted the adjournment slip, your Lordship.
Why?
Actually, your Lordship, Mrs. Begum, she was about to appear, your Lordship, but she is out of station, your Lordship.
But outstation cannot be a ground to adjourn this
Her
6-year-old man.
sister, her elder sister is not well, your Lordship, so she has run there, your Lordship.
Normally, we don't appreciate this. Just going out of the town, so that means adjourn.
No, your Lordship.
Cannot expect that. Next time, don't repeat it. Adjourn the prayer of sense.
Oblige, your Lordship.
लिख लीजिए। ना ये whenever it is listed ना।
Oblige, your Lordship.
नाम तो ले लो। Item 1 for motion. 8 and 13 ना you know.
May I please your lordship? My lord, in this case, I had filed 2 affidavits which I intend to adduce their evidences before the learned tribunal.
That Johar Ali of 65
Yes,
of
lordship.
Bhandara
Yes,
had
lordship.
shifted to village so and so.
Yes, there is shifting, lordship.
How do you prove it?
Yes, the 2 evidences I have filed. One of Azizul Haq,
Page number
running page number 56, lordship.
6.
He is the ward member,
Running page 56.
56, lordship.
It's an affidavit by Azizul Haq.
Yes, lordship. His evidence we want to adduce before the learned tribunal, lordship.
He is born, he is of village Bhandara.
Bhandara, number 3, part 3. And Bhandara part 1 and part 3 is at a distance of 500 meters. So it's one area only.
How does he know he shifted to Ishwar Jari?
Because as a ward member, he has issued a certificate
He may
also.
have issued.
Yes, lordship.
This is where we are trying to get a little more deeper. Merely because a person is a ward member, he is a secretary, he is a Gaon Bura. There is no constitutional authority given to this person that you can issue certificate declaring anybody's right in any manner. Their status and that of any other witness, we don't see any parity between them. So whenever any witness intends to give evidence on the existence of a fact,
Yes, lordship.
that has to be backed by either personal knowledge or if he custodian of record on the basis of the records he is maintaining. These are the only 2 circumstances a person can give evidence.
Yes, lordship.
If this person would have said that, yes, I have a close relation with this family. I also visited their house at Ishwar Jari,
Yes, lordship.
and I can vouch that, yes, this is the same. It's a good evidence.
Yes, he has
Hmm.
stated that.
He has
since
only
childhood,
stated, has shifted
Childhood.
his residence. So
and I
now,
know petitioner
suppose
since
today
childhood.
I am your neighbor. You know me very well.
Yes, lordship.
Tomorrow I go and shift to another place. Unless there is evidence that you came to my new place,
Yes, lordship.
personally seen me there,
Yes, lordship.
you cannot render evidence. At the best, I can tell you, yes, madam, I am going from here, but next I'll be staying in that other place. That knowledge will be hearsay for you.
Yes, Lordship.
This is the question we ask in every petition. How
Yes,
do you
Lordship.
overcome this?
And even the another person, his evidence also, Lordship.
Which other person?
Other person, page 66, Lordship.
66.
Afzal Hussain.
Uh,
Afzal Hussain.
66. How do you link up these two evidence?
And Afzal
See,
Hussain.
this man can give evidence that now I'm a man of Ishwarjari village. So from 84, this man is here.
Yes, Lordship.
But how do you link up that these
So
two persons
this-
are the same?
This person, Lordship, Afzal Hussain, he is also the father-in-law of the petitioner, Lordship. He resides in
Father-in-law of the petitioner.
petitioner, Lordship. He resides in Bhandara Part 1. So, writ petitioner, he
So
has.
he has some knowledge.
Yes, personal
This-
knowledge, and
this
even he
can
has
be
a
accepted.
relationship, Lordship.
This person we accepted.
Yes, Lordship. So his.
So
he has-
the source of knowledge will also have to be explained.
Yes, Lordship.
This one we accept.
Yes, Lordship.
Yes, Mr.
That may be remanded for.
Heard MSD goes to council for the petition. The petitioner claims that
Nineteen sixty-five is at page
That-
29.
his father Johar Ali, whose name appeared in the voters list of 1965 of village Bhandara number 1, police station Bijni, had shifted to village Ishwarjari Part 1 under Jogi Ghopa police station. Full stop. To substantiate that, Johar Ali had shifted from Bhandara number 1 village Bhandara number 1 to village Ishwarjari Part 1. Evidence of Afzal Hussain through the additional affidavit filed before the High Court is being relied upon, where Afzal Hussain claims that the writ petitioner is his son-in-law and that he is a resident of village Bhandara Part 1. And he has personal knowledge that the writ petitioner had shifted from village Bhandara number 1 to Ishwarjari Part 1. View of the above, the privacy case.
Lordship, he is in detention, Lordship.
Detention release or order to DG. They release from detention. What will you do with him? Detention
Deeply
releases it to at a paragraph, then add the interim.
Deeply blessed.
Item 2.
Is the IVs bail bond of something?
May I please, Lordship? My lord, in this case, my lord, father of the my lord OP also deposed, my lord. Father of the OP, my lord, deposed, my lord.
Father of the OP.
My lord, page 28, my lord.
What does the depose?
No, that he admitted, my lord,
Jahera Khatun. Who is the father of Jahera Khatun?
yes, my lord, page 28, my lord, he is deposed.
Page 20.
Page, my lord.
So how can a father declare? How do you know he is the father?
My lord,
Before you come to that father had declared, you'll have to show that that man is the father.
yes. He
How
claimed,
do you know that he is not a man from the street? We just brought in, claims that he is my son.
Yes, my lord.
How do you know that? Prove it.
Prima facie, my lord, his voter, in the voter list, his name is there, my lord.
Whose name?
Father's name, my lord.
Hussein Ali. Where is it?
My lord, his voter list, my lord, page 50, my lord.
Page
Page 50, my lord.
50.
50, my lord.
What's the name of the person?
Hussein Ali, my lord.
Hmm.
Hussein Ali, my lord.
Son of Mongolia. He is of
Mongol,
he's a voter list of 77.
77, my lord.
How do you know Hussein Ali is a citizen?
Mongolia, my lord, page 46, my lord. And my lord, page 48, my lord.
Page 46, Mongol Sheikh. Village Silongili. Wrong version again, no? Yes, Mr. Sharma. What do you have to say?
Notice was not issued, Lord. Notice may go at this.
Notice are interim to Ditovo. Petitioner claims that Mongol Sheikh of the 1966 voters list of village Silongini is his grandfather, whose name also appears in the voters list of 1970. The voters list of 1977 of village Silongini contains the name of Hussein Ali, son of Mongol Mia. And it is claimed that Hussein Ali is the father of the petitioner. To substantiate the same, Hussein Ali, son of Mongol Sheikh of village Silongini, had deposed before the tribunal as DW2.
Item 3 for admission.
In the meantime, my lord. Diploma.
Yes, Abdul Rashid. Yes, it does.
Well,
Ever to
here
produce any further voters list of village Rampara subsequent to the shifting.
My lord, father's name is not in voter list of 1966, but grandfather's name and mother's name.
Page number?
At page 34, my lord.
Page 30.
Grandfather Tarifullah Sheikh, grandmother Hazira Khatun,
Grandfather is
Faizila Bewa is mother,
Tarifullah Sheikh, his grandfather,
grandfather.
and Hazira.
Hazira Khatun is grandmother,
Ah.
Faizila Bewa is mother, wife of Sobur,
Manjila Bewa,
wife of
mother,
Sobur.
wife of Sobur. And who is Sobur?
My lord, Sobur is the father of the.
No,
petitioner.
Sobur is son of Tarif,
Sobur is the son of Tarifullah Sheikh.
but he died.
He died before the grandfather, my lord. Before the
Understand.
1966 voter list died, my lord. But
Is there any?
my lord, some other documents in the name of father, my lord.
No, no, Mr. Sikdar, is there any other document, prior voter list
My
showing Tarif and Sabur
Yes,
together?
my lord. That I am saying.
56
my lord.
or
Page 71, my lord. Revenue paying receipt of
page
1956.
71.
71, vernacular 72.
This is
Revenue paying receipt of
revenue
319056.
paying receipt. Okay, receipt.
There
from
are some other
Sabur.
also at page 73, 74,
74.
my lord. Fathers in the name of
So
father.
now Sabur is the father.
Somebody is the father. Then my lord, the linkage lordship will be,
No, no, if Sabur is the father, how do you show that Sabur is the father?
my lord, that is my lord. I am coming to John the copy of
Page number.
annexer 17, page 77. My lord, relevant person lordship will find vernacular at page 78. My lord, in the remarks column,
Jamabandi. Of-
the order of the
No,
circle.
this is the difficulty. Rampara Palm. Other
Yes,
village-
Rampara. Same village.
Huh?
Same Ramapara, my lord.
Ramapara Palm. It's okay.
My lord.
So Ramapara Palm,
My lord.
in place of Tarifullah,
My lord.
it is also
Tarifullah.
Sobur.
Yes, my lord.
Sobur
Sobur
is
is there.
and from Sobur, what is the name of this petitioner?
My lord, Abdul Rashid.
Abdul Rashid.
At
Where is
serial
Abdul?
number 5.
Yes, Mr. Fine. Something is there.
Yes, my lord.
Let it go back, let them examine.
Yes.
You will also give more evidence. You also
Yes, sir.
verify.
Let him examine, my lord, let him find the certified copy of the order, my lord, as well as.
There you make all kind of demands. That you bring this, bring that, whatever it is. Heard Mr. A.R. Sigdal, learned counsel for the petitioner, also heard J. Pine, but it may be revoked. The petitioner Abdul Rashid had been referred to the
My lord, improved order
foreigners tribunal number
at page 66, my lord.
66, been referred to the foreigners tribunal number 5 at Gwalpara for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number FT/5/278/2016. The tribunal rendered an opinion dated 12/7/2017 declaring the petitioner to be a foreigner, being aggrieved this writ petition is instituted. In the writ petition, reliance is placed on the voters list of 1966 of village Rampara Pam, police station Bagbor, Moza Bagbor in the present Borpeta district, which contains the name of Tarifullah Sheikh, son of Hadu at serial 230, and that of Hazira Khatun, wife of Tarif at serial 231, and that of Monzila Bewa, wife of
Faizila Bewa,
Moizila Bewa, Faizila Bewa, wife of Sobur at serial 232, and all of them are shown to be residing in the same house number 55. It is stated that Moizila Bewa is the mother of the petitioner and Sobur is the father, and that Sobur is the son of Tarifullah Sheikh. But unfortunately, Sabur predeceased Tarifullah Sheikh, and therefore his name does not appear in the voters list of 1966. To show that Sabur is the son of Tarifullah, reliance is also placed on certain revenue-paying receipts of 1956, right? Dated 3/1/1956 and 28/1/1958. Which contains the information that the revenue amount was received from Abdul Sabur, son of Tarifullah, in respect of a plot of land in village Rampara Pam. Ramapara Pam. Accordingly, it is sought to be established that Abdul Sabur is the son of Tarifullah, that is Tarifullah Sheikh of the voters list of 1966. To substantiate that the petitioner Abdul Rashid is the son of Abdul Sabur, who in turn is the son of Tarifullah Sheikh, reliance is placed on a Jamabandi of a plot of land of village Ramapara Pam. Which page is the Jamabandi? 78. Wherein, as per the order of the circle officer dated
10/10/2017.
10/10/2017 in mutation case number BAR/BAG/2017-18/806/FMUT. Land had been mutated in favor of, amongst others, Abdul no, where is the name of Abdul?
Abdul Rashid.
Abdul Rashid. Where is his name? No, nothing order to. Abdul Aziz is there.
Abdul Aziz, my lord.
Sobura Khatun is there. Nur Jahan Begum is there.
My lord, Rashid is in the
And,
page 78.
Sorry.
Rashid is in at page 78, my lord. Last, my lord. Uttaraধিকারী হচ্ছে সবুর হোসেনের স্থলত Abdul Rashid.
Sorry.
Then, my lord.
Mr. What we are not getting is Abdul Rashid.
My lord.
Although we are getting Abdul Aziz.
My lord. There may be some.
The name of Abdul Aziz, son of Sabur, had been mutated in place of mutated. But in the name of the Patadars, it is indicated that in place of Tarifullah Sheikh, son of Hadu, and Sabur Hussain, son of Tarif Uddin, the name of, amongst others, Abdul Rashid had been included, showing him to be son of late Sabur Hussain. Accordingly, the petitioner claims that he had established that he is the son of Sabur Hussain, son of who again is son of Tarifullah Sheikh of the 1966 voters list of village Ramparapam. In view of the above, remanded back to the tribunal to examine the veracity of the voters list of 1966 of village Ramparapam, the revenue paying receipts of 82 dates, 56 and 58, as well as the Jamabandi of the plot of land of village at village Ramparapam, and pass a reason order on the claim of the petitioner that he had discharged the burden under Section 9 of the Foreigners Act 1946. To facilitate the process, the petitioner to produce the complete voters list of 1966 and all other subsequent voters list of village Ramparapam, the revenue paying receipts of 1956 and 1958, date to DDO, and as well as the complete order of the circle officer dated so and so, full stop. The respondents in the Home Department may also make their own verification on the veracity of the aforesaid information contained in the aforesaid documents and submit the report before the tribunal. Both the petitioner as well as the respondents may use any further evidence is so advised. Upon doing so, reason order be passed.
Item 4.
Item 4, my lord. I'm seeking some time, my lord, in this case.
Earlier case, where is one? Mr. Siddharth. Yes, Mr. Sakar, you start.
My lord, in item number 4, my lord. Item number 4, I'm seeking some time for.
John on the prayer, Mr. J. Pang, then counsel for the Home Department.
Item 5.
My lord,
Just send for Mr.
yes, yes,
Siddharth. Yes.
my lord.
Sabia Khatun. Why? Superintendent Police borders shall remain personal.
But on 19.
Under what circumstance, when
95
there
okay,
was a
that's an
direction to
order.
to make it, the inquiry had been conducted through the sound? Yes.
Well, it was the inquiry was
See,
conducted by the
We
SI.
have some bigger trust on the police.
Lot.
So we asked the police to make an inquiry.
SI of police has conducted. It was
No, because possibly at that moment, we had less faith on the sub-inspector.
logical.
Now, why did you delegate it to him?
But it has been
Police has enough machinery to make all kind of verification, all kind of inquiry. When the police makes an inquiry, the impact is different. The result, we have more faith on a police inquiry. Sub-inspectors, they do whatever they feel like. And the direction is specifically to the superintendent of police border, not to the sub-inspector. If we need any inquiry from the sub-inspector, we direct him also. But this was a stage that was beyond the sub-inspector. Now, what does the,
what the report has come around. He has now undertaken the inquiry.
so when we ask the SP to do it, you do it.
Logical.
SP can depute another reliable police officer, that is another factor.
Okay.
It's not that you have to personally go to that place. But that doesn't mean you give it to the sub-inspector of schools.
No, it was wrongly, my lord, mentioned as school. It is sub-inspector of police, my lord.
I
He-
don't know. What the
Lord.
record police before
Lord.
us, since we
It
go
was,
by
it
the,
was, it was,
we have no means to go beyond the records.
correct, correct. Lord. Now this has been rectified, my lord. Yes, sir. Yes, sir.
See, these happenings took place in 1983, 82, and 1981, 82, and 83.
Lord.
There the name is Chabia,
CH,
CH.
Lord.
In 2011, the headmaster issues a certificate
Lord.
to one Sabia. This time it is S.
S.
It may be the same person, maybe a different person. No one knows.
Well, this statement of the
Huh.
headmaster, kindly see the next page, my lord.
Understand?
Lord.
Now headmaster does it in good faith.
Yes.
What good faith he has?
Lord,
Because he was not the headmaster in 1981.
no,
Had he been the headmaster in 1981, we understand that down the memory lane, I could find that 30 years ago, it was Sabia and not CH Chabia.
Correct.
And therefore, it was an inadvertent mistake. I corrected it. We understand.
and there is no written application also.
Nothing is there.
Is there.
And the school attendance register shows it is CH, not S.
It is CH. Registers are there.
So how can the headmaster in 2011 give a certificate that this person with beginning with S and the person beginning with CH are the same, and therefore in 2011 now I correct the school records? How can he do it?
No,
Don't you think this is little fraudulent? Or
Logic.
there is a possibility of it being fraudulent?
yes, yes.
We don't know whether it's fraudulent or not, but there is a possibility of being fraudulent.
On the part of the.
So
headmaster.
anybody can tomorrow come.
Yes,
Because this original Shabia must be happily married somewhere, is not bothered with these certificates. Because there is no proceeding against this one. There is proceeding against a person called starting with S.
yes.
That person wants a
Certificate.
certificate. And mind you, these people, I don't know whether the SP is aware or not. A kind of racket is also in existence, where they have an information bank with them. Anybody coming with a name, the information bank is activated and found out where a similar name is available.
If it resembles, they used to,
Go to that.
yes, yes. Madam.
How do you rule out this aspect? You make further inquiry, tell us.
But case has been registered, they will do it. The registrars are also here.
But
Logic.
if it happens
Logic.
that actually one name with S was wrongly written as CH, and it is the one and the same person, matter is different.
Different.
It's not that we are holding any view against them at present. But that has to be ruled out. And because of the prevailing circumstance, it is furthermore required to rule out. Because when you know that these kind of things are available everywhere, we have seen school records have been manipulated. I think you are aware.
Yes.
Every
yes,
case we refer to you only.
Yes, yes. Almost in all schools, this problem is there.
So now we have, initially we are dealing with that the school headmaster will depose before the tribunal from the original records. We have gone a step further now. We want the school records to be produced before us so
Yes.
that we can take a look at it.
Yes, sir.
All things are happening. Out of that, genuine people are also there, fraudulent people are also there, but you have to what is called separate the grain from the chaff.
Correct.
You have to do it.
The attendance register of 83 is here. Now the attendance register is with us.
The report
Yes.
says attendance register does not show all these names.
No,
Yes.
attendance register.
So
shows
the
CH.
So when it is CH, the original was right. This 2011 headmaster, in his enthusiasm to issue a certificate to another person, he corrected that also.
In fact, in 11 also, he first wrote CH.
Hmm.
Then it was corrected.
Then when the person said that I am not CH, it is S,
Possibly.
give it.
But now the headmaster has said that no, এই ক্ষেত্ৰত কোনো ধৰণৰ লিখিত আবেদন দিয়া নাই।
Who দিয়া নাই? কোনে দিয়া
The
নাই?
person, the statement of the headmaster is there.
No, কোনে দিয়া নাই?
The person concerned,
That person is starting with S.
yes. His statement, I'm just
No,
reading.
no, it is immaterial whether written application was there or a oral request was there. He had done this act.
No, on the basis of something he has to do that. There is no basis.
No, basis is the person approached him. That is the only basis.
That is the basis. In fact, he said that মোক অনুৰোধ জনাইছিল।
অনুরোধ জানাইছে, the headmaster Bachadhan Sharma had some good feeling for this person. Okay, don't worry, young lady, I'll help you. Do it.
Well, now the case has been registered. Malad. It will be, investigation is going on.
So AMS Modular, you wait till the report comes. But if the inquiry reveals that it is the same person, we'll exonerate you, we'll accept your certificate. With some stricture to these headmasters and all, don't do all these acts. Because the headmaster, what he ought to have done? He ought to have said that no one person with CH was a student in my school. I cannot issue this certificate. Go and get some further material from any appropriate authority that you are one and the same person. Yes, I issue to you. You ought to have done that.
Normally for correction of name or change of name, some affidavit, notarized affidavit or
Something
registered
is there.
affidavit, those are required.
And whether your spelling is right or it is wrong, the original spelling written in the school record remains your name for your entire life,
Logic,
unless it is changed by some specific order.
logic.
It remains. Even if it is wrongly written, there are many people whose name are wrongly written and they retain that name for their entire life.
Yes, yes,
Why the school record entry was wrong?
correct. Logic, logic.
Land document আছে।
Investigation to go on, like, police service.
Pursuant to our earlier order of 19/5/2023, the Superintendent of Police Border Kachar is personally present before the court. The circumstance in which the earlier inquiry was conducted has been explained. Explanation is accepted. A further report has been produced. Report dated 22/5/2023 has been produced by the Superintendent of Police Border. The same report is kept on record. Further update of the Borkhola PS case number 65 of 2023 be provided to the court on the next returnable date, list after how much time?
Lordship, give us 4 weeks time, Lord. It has. to
4
be
weeks
sent to-
time. Let's
sent to
again
the-
on
sent to
Swinstone.
the- Lordship. Hold on.
It's really more.
Well, the personal appearance may be
A
dispensed.
person, just.
Lordship. Hold on.
And Mr. SP, we need some more cooperation from you in these proceedings.
Right.
Time to time, we'll keep on getting some orders. You please cooperate.
I assume.
And as you are here, and you also tell all your colleague SPs in the various districts, we need some more proactive role of the superintendent police border. Now, what is happening is you feel that once the reference is made, your duty is over. It is for the tribunal to do whatever it wants to do. Do you think it is right? Or is some further role is there? Which is, you said nodding to head both the questions.
Yes, sir.
Which ones? Further role or no
Yes, sir.
further role?
Further.
Further role. What is the further role? Please come forward. What is the further role?
So in this case, sir,
No, in these tribunal proceedings, what
Yes,
is the further role of the SP border?
say, we
Apni
have, sir,
Ohamiya kok, যদি if you are
Oh.
comfortable, English, Hindi, whichever you are comfortable.
মহোদয়, বহুত সমস্যা বহুত আছে মোৰ ডিষ্ট্ৰিক্টখন কাছাৰ জিলা
So,
কাছাৰ জিলা
so,
স্যার,
সমাধান বোলাও এটা কথা
হয়,
আছে।
স্যার, হয় স্যার সেইটো
সেইকাৰণে
বহুত
সমস্যা
আছে।
থাকে।
হয় স্যার
নহলে সমাধান শব্দটো নাথাকিবই,
স্যার
যদি সমস্যা নাথাকে।
Sir,
You
that-
have to find your way out.
কাছাৰ জিলাখনত স্যাৰ পাছপোৰ্ট লৈ বহুত সমস্যা হয় সেইটো আমি
We are not on
বিচাৰো।
those. We are asking you what further role you have once a matter is referred to the tribunal. Tribunal আপোনালোকে refer কৰাৰ পিছত
Sir,
আপোনালোকৰ আৰু কি role বাকি থাকে, কি কৰিব লগা বাকি থাকে?
Sir.
কি থাকে?
স্যার
অকল refer কৰি is it the end of your duty or you have some
সেইটো ফলো আপ কৰি থাকিব লাগিব
follow up কেনে ধৰণে কৰিব?
অফিচাৰ আমাৰ যি
ন অকল গলেই নহব, অকল অফিচাৰ যাব চাই থাকিব কি হয়, তাতকে বিয়ন কি কৰিব লাগে?
স্যাৰ মই অনাৰেবল মেম্বাৰ সকলৰ লগত মই
নাই, আপুনি মেম্বাৰৰ লগত কথা পাতিব নোৱাৰে, হি ইজ এ জুডিচিয়েল অফিচাৰ, একেবাৰে নোৱাৰে, কন্টেম হ'ব আপোনাৰ। মেম্বাৰৰ কথা পাতিব গলে কেতিয়াও নোৱাৰে কৰিব এইটো। And will not permit you to do it also. Your role is, আপুনি section 9 Furnace Act 46 পঢ়ি চাইছেনে? Please give him that পঢ়কচোন এইখন। Give me one of this Furnace Act section 9. কি লিখিছে তাতে?
if any case not any case not failing under section 8, any question arises with reference to this act or any other made or direction given thereunder, whether any person is or is not a foreigner or is not a foreigner of a particular class or description the onus of providing that such person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall be withstanding anything contained in the Indian Evidence Act 1872, lie upon such person.
তাৰমানে ইণ্ডিয়ান এভিডেন্স এক্টে কি কয়? যোনে কেছটো ৰুজু কৰে তেওঁৰ বাৰ্ডেন কেছটো প্ৰমাণ কৰা। আজি আপুনি চিভিল সুট কৰিলে, you are the plaintiff, it is your responsibility, your to burden of proof যে আপোনাৰ কেছটো নিজে প্ৰমাণ কৰা। এইটো কেছত burden of proof has been reversed. এইটো যদিও ৰেফাৰ আপুনি কৰে, proof কৰিব প্ৰচিডিয়ে, so the burden of proof has been shifted. Burden of proof shift কৰাৰ পিছত তেওঁলোকে যদি complete বা incomplete বা half complete material দিয়ে to prove that he is a citizen, what is your role thereafter? আপোনালোকৰ কি কাম তাৰ পিছত? আপোনালোকে এতিয়ালৈ যিটো কৰি আছে, you are only raising doubts, discrepancy, this, that, যে এইবোৰ material ল'ব নালাগে, তাতকে বিয়ন আপোনালোকে একো নকৰে। If that fails, what will happen? He has proved, but you are not rebutted that evidence. আপনার এটা ডিউটি নাই জানো টু মেক এ ভেরিফিকেশন যে তেওঁলোকে ক'লে যে 1960s অমুক গাঁৱৰ ভোটাৰ লিষ্টৰ অমুক মানুহজন মোৰ ইজ মাই ফাদাৰ। আপোনালোকে এটা সেইখন ঘৰত গৈ সেই গাঁৱতো সেই মানুহজনৰ যাতে আছে সেই ঘৰত গৈ এটা এনকুৱাৰী কৰিব নোৱাৰে নেকি যে তেখেতৰ ল'ৰাকেইটা আছিল অমুককেইটা আছিল আজিকালি ক'ত থাকে ল'ৰাকেইটাৰ নাম কি? যদি আপুনি এইখিনি খবৰ লৈ আহে যে এক্স মানুহজনৰ 3জন ল'ৰা আছে A, B and C, কিন্তু যিজন প্ৰচিডি তেওঁ যদি সেইজন মানুহক দেউতাক বুলি ক্লেইম কৰিছে হি ইজ নট এমংছ A, B and C, হি ইজ সামথিংবডি এলছ, ই বা এফ তেওঁ, আপনি ট্রাইব্যুনেলৰ আগত কৈ দিব যে এওঁলোকে এটা ক্লেইম কৰিছে যে অমুক ভোটাৰ লিষ্টৰ অমুক মোৰ দেউতা, আমাৰ এনকুৱাৰী মতে এইটো ইনফৰমেশ্যন ৰিভিল কৰে। ডিসাইড কৰাটো সহজ হ'ব নে নাই ট্ৰাইব্যুনেলৰ?
অবশ্যই।
আপোনালোকে একো নকৰি যদি বহি থাকে হিয়াৰিঙৰ সময়ত খালি এটাই কথা ক'ব যে আমি বিশ্বাস নকৰো এইবোৰ কথা। আপোনাৰ বিশ্বাসৰ কোনো আইনৰ জাগা নাই। It is your personal, you believe or you don't believe. Law says he has discharged the burden. So foreigner declare কৰিব লাগিব, Indian declare কৰিব লাগিব। On the other hand, আপুনি যদি এইখিনি এনকুৱাৰী কৰে ভেৰিফিকেশ্যন কৰে সঁচা কথাটো হয়তো ওলাই গ'ল হয়। স্কুল চাৰ্টিফিকেট দিছে, আপোনাৰ পুলিচ এজন পঠিয়াই স্কুলৰ ৰেকৰ্ডটো চোৱাত কিবা দিগদাৰী আছে নেকি? নাই। যেতিয়াই দেখিলে যে প্ৰচিডি আহি এখন চাৰ্টিফিকেট দিছে অমুক স্কুলৰ পৰা যে হেৰি আপোনাৰ কি অসুবিধা আছে সেই স্কুলত এজন পুলিচ পঠিয়াই দিব যে মই ৰেকৰ্ডটো চাওঁ কি আছে। ৰেকৰ্ডত যদি বেলেগ কথা আছে আপুনি ট্ৰাইব্যুনেলক কৈ দিয়ক যে এখন মিছা চব। Why don't you do this much? ভাল হ'ব নে নাই দেশৰ কাৰণে?
ভালো হবে।
নকৰে কিয়? এতিয়াৰ পৰা কি হৈছে যোন জেনুইন মানুহ তেওঁক ক'ৰবাত ফৰেনাৰ ডিক্লেয়াৰ কৰা হৈছে, যোন ফৰেনাৰ তেওঁলোক ইণ্ডিয়ান চিটিজেন বুলি ওলাই গৈছে, বিকজ ইউ আৰ নট ডুইং ইয়ৰ ডিউটি। Why don't you do a complete duty? Make your office more active. এইখিনি কৰিলে আপোনাৰ সমস্যাৰ কথা যে ক'লে সমস্যা সমাধান হ'ব নে নাই এইখিনি কৰক। আৰু spread this message amongst all the superintendent of police border, and on the next date give a copy of that circulation to Mr. Nath. He produce it before the court. আপুনি সবকে যাতে আটাইখিনি এসপিক যাতে এইখিনি কথা কৈছে, make this circulation as per the order of the court বুলি কওক। As required by the court, I am circulating that this is the what is the requirement. Or সেই circulation to give it to us. এইখিনি কৰক, অলপ দেশৰ কাৰণে কৰক। আৰু আপোনাৰ অফিচৰো অলপমান বেছি বেটাৰ হ'ব। Every evidence made, make a verification inquiry whether it is right or wrong. And if it is right, report দি দিয়ক না, এজন মানুহ সঁচা সেই তেখেতৰে পুতেক। Why you trouble this person any further? যদি দেখে যে নাই সঁচা হয় কথাটো, আৰু যদি মিছা হয়, tell the tribunal. Now the tribunals are neither in a position to decide this way or not that way. If they declare a person to be a citizen, that will be wrong because there will be insufficient material. If they declare a man to be foreigner, that will also be wrong because the material is insufficient. Why? The state is not doing the needful as required. Please do it. And give the circulation. We want a copy of it. Thank you. Oh, Mr. Shigdar, we have referred to one that order of the circle officer.
Yes, sir. I do.
Dated 10/10/2017. Anyway, I'm reading it, don't have to read the file. At page 78 and 79. Please take note that the name of Abdul Rashid is not there.
Hello.
Abdul Aziz is there.
Hello.
And there is another son named Abdul Aziz.
Abdul Rashid is there, but there may be some mistake in.
Find out where is the mistake. Abdul Rashid is not there. Maybe Abdul Rashid was mutated earlier because Sabur already died. There's a possibility
There may be some mistake, my lord, in the.
Just find out where is the mistake. Otherwise, Rashid is not there. We are just pointing out. Yes, next item.
Item 6.
Yes, Abdul Ali,
Father is Kurban Ali Lordship,
page number
page number 50.
50.
Now,
Who is Ali? Kurban.
Kurban.
Kurban is the father.
Yes, Lordship. Dumura Pathar,
Dhumar Pathar,
Dumar Pathar.
Thana Horbog. Okay, now which document show Kurban is the father?
Page 52, Lordship.
52. Abdul Ali,
Abdul Ali.
petition.
243 is Kurban Ali, 244 Abdul Ali.
Go back, produce all the voters list.
Yes, Lordship.
Third MSD Ghosh and counsel for the petition. The petitioner Abdul Ali had been referred to the foreigners tribunal number
Number 3, Borpeta Lordship.
number 3 Borpeta for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of
Page
FT
31.
case number 2167 bracket Roman 3 of 2016. The tribunal passed an order dated 27/12/2018 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1970
70.
of village Dhumar Pathar, police station Horbog, Mohkuma Borpeta in the present Borpeta district, which contains the name of Kurban Ali, son of Samsher Ali at serial 229. It is stated that Kurban Ali is the father of the petitioner. Petitioner further refers to the voters list of 1989 of village Dhumar Pathar, which contains the name of Abdul Ali, son of Kurban at serial 244. Any voters list containing Morian Nessa and Kurban Ali together in between?
85, no, 85 is not there,
Mhm.
Lordship. No, Lordship. Because that also is, 70 also is not a full voters list. It's only
Whatever it is,
3%.
do we have anything? The full stop. If the information contained in the voters list of 1970 and 1989 of village Dhumar Pathar is correct, the petitioner may have discharged the burden under section 9 of the Foreigners Act 1946 that he is a citizen of India. But however, it is noticed that although the two voters lists are of the same village, but there is no continuity in the voters list between 1970 and 1989. And therefore, the petitioner would be required to produce the complete voters list from 1970 to 1989 of village Dhumar Pathar. The petitioner it is also noticed that Morian Nessa is one of the wife of Kurban, whereas Abdul Ali is the son of Kurban as per the voters list of 1989. But no voters list is available where the name of Morian Nessa, wife of Kurban, and Kurban may appear together, either in 1970 or any of the voters list thereafter. Petitioner to also produce any such voters list which may contain the name of Morian Nessa and Kurban Ali in the same voters list. So, the respondents in the Home Department may also make their verification on the authenticity of it, as well as whether the petitioner Abdul Ali and Abdul Ali of the 1989 voters list of village Dhumar Pathar are one and the same person. They are of the pass a reasoned order.
He may adduce more evidence if we get
I,
more voter list.
Both the petitioner and the state may be allowed to produce any further evidence if so advised.
deeply obliged, Lordship.
My lord, in my case, my lord.
Your case is over. We already passed you. over.
One line is dropped, my lord.
I don't know.
There is 3 line in the order in the CVS 78.
Mr.
one line is
Sikar,
dropped, my lord.
we read whatever is given to us.
My lord,
We cannot read what is not given to us.
I am sorry, my lord. That's it.
Item 7 for hearing.
Yes. Ali Hussain Sheikh
Last
is-
order. Lord. Last.
Where is Mr. S. Dotto? No one is responding. By the order of 16/3/2023, the president of Sonakuli Gaon Panchayat and Golaganj Police Station of Dhubri district was required to file an affidavit stating as to what is the source of knowledge to support the information contained in the certificate dated 25/10/2016, which is annexed as annexure
Annexure 1 of additional.
as annexure 1 of the additional affidavit. Do you appear for somebody
Mr. S. Doctor informed me he's on Lake City, Canada.
after some time?
Item 9.
This item nine, Musammat Fuljan Nisa.
My lord,
Who is the father of Fuljan Nisa?
Sir Akhtar Ali, my lord.
Page number. Page number.
Beg pardon.
Page number. To file Nayana.
Annexure 1, my lord. Page number 8. Page number 7, 8.
Now, who is the father?
Akhtar Ali is the father of the,
Akhtar Ali.
yes, my lord.
Akhtar Ali father.
But my lord, in the
And
reference,
which document will show that Akhtar Ali is the father of Fuljan Nisa?
my lord, that document was not produced in the tribunal, my lord, but I have got one document. my lord.
Which page number, Mr. Das?
Page number to Pulji.
My lord, I have got it. It is not exhibit. It is not set in the reference. I have got it with my lord. Page above 7. One sentence is there, my lord, saying that
Yes. Mhm. Send it. Hazira Khatun.
number 2 is the Fuljan Nesa, my lord.
Fuljan Nisa.
Petitioner.
Fuljan Bibi Uruf Muhammad Yunus Musani Pita Akhtar Ali
My dear.
Mozana Gaon Kanchanpur to her. 19 Likhit Yes, you rely on this sale deed.
Yes,
Yeah,
and
one-
this was
one more
not exhibited as per it.
It's okay, you can go back and
Remand back-
exhibit.
Yes, if we remand back and he may exhibit this
Okay.
document.
Send it back.
Yes, Lordship.
Heard Mr. B.C. Das, and counsel for the petitioner also heard.
My lord, one more thing, my lord. The petitioner herself was recorded as a citizen of India prior to 1971, my lord.
Which page?
My lord, I have got the record here. It is page 3 and 4, my lord.
Why don't you go and produce that document before the tribunal? That this is.
Her husband also was recorded as a citizen, my lord, and she has got her legacy data also. And as per my advice, they procured these documents later on, my lord. Her husband's legacy data is also at page 9, my lord.
And where is the notice of the tribunal? To whom it is issued? Just check.
Notice is the terminal. Notice of the terminal is our page 1.
At page 1 of the bunch, Lordship, we just given you. To Fuljan, Lordship.
Son of Vinas. Wife of Vinas, okay, we say Fuljan Vinas. Yes. Fuljan, wife of Vinas, what is this, the same 1971. No, Verma,
Yes, Lordship.
the notice is to Fuljan, wife of
Inish, Inash.
Innas or Yunis, whatever it is.
Yes, Lordship.
Fuljan has a voter's list of 1971 in her own name.
Yes.
If this is the person, she is the person.
And these documents were not exhibited. My friend may go back now, Lordship, and exhibit all these documents. I'm sure the opinion will. be
Sometimes
fine.
the cases are also very badly conducted. Frankly, some incompetent people are also handling the cases in the tribunal. Some are very good, but some are quite incompetent also. They just take it to be a regulation method. I got a client, take money, that is the end of the matter.
Yes.
Tribunal go for a few days. Yes, I have done my duty. Whatever happens, what is to be done, it's nobody's botheration. See, way Mr. Das had asked the client, discussed it. The same the other lawyer also to have done.
Would have gone. And now all documents are in order.
These are all.
Yes.
It may not be another factor, but at least it worth considering in these documents.
Yes, Lordship. And a very fair submission that none of these documents were
Yeah.
exhibited before the tribunal.
So Mr. Das must have used his legal acumen to gather this information from the petitioner.
He stated that on his advice, they got all those documents.
So somebody applied his mind, these things come out.
Yes, Lordship.
Other lawyer not bothered at all.
Whatever comes, they go ahead with that.
And some of the feedbacks that we are getting is that most of the occasion, the lawyers don't even allow these people to enter their premises also. Sign this document, give the money, and you just go away.
Even we have.
Rest is my responsibility to do, and ultimately he will not do anything.
This is
How
sad
do you
state
protect
of
these
affairs.
people from that approach?
Lordship, they go themselves, they are some, to
What
some
to do?
reference.
See, you may be a very conscious person. When you are sick, what do?
Visit a doctor.
Visit a doctor. If you're a very conscious person, you have a lot of connections here and there, you'll ask too many people, this is my problem, which doctor to go? You'll take somebody's advice, go to the appropriate one.
Yes.
What about a common man? The common man will go to any person whom the person knows to be a doctor. Caliber of doctor, what kind of doctor,
They don't know.
don't know. Same is the state with these litigants. They, no doubt voluntarily went to that lawyer, but doesn't know.
Lordship, then it is the lawyer's conscious duty to take it up.
Definitely. What
It
is the
is
remedy?
consciously, it has to be done, Lordship.
What is the remedy for all this? Nothing.
It has to come from within. Lordship cannot pass any stricture, any.
What to do? How can you pass also?
It is
See, in this case, just because Mr. Das, he applied his mind a little extra and found out every possible
That's what-
document which is in favor of the petitioner. Why the same could not have been done in the tribunal by that lawyer? It's time somebody takes up these issues. At least some,
Lordship will show us the way, Lordship, we are always ready to.
no, no, what, how can we show you the way?
Because it's difficult to generalize it also, Lordship.
Name of the lawyer is also not written.
With that, we can get it from the records, Lordship, if the.
No,
record-
no, this order is nothing is written.
And the LCR is there, he must have filed some adjournment petitions or some other documents, Lordship. Filed by would have been there.
Heard Mr. BC ask in counsel for appeal. The petitioner, Musammat Fuljan Nessa, had been referred to the Foreigners Tribunal number 2, Nagaon, for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 146/2016. The tribunal rendered an opinion dated 25/10/2017 declaring the petitioner to be a foreigner, being aggrieved district petition is instituted. Stop. In the tribunal, amongst others, the petitioner exhibited a certified copy of the voters list of 1970. Produced a voters list of 1966-65 of village Kanchanpur and a police station Rupahi Hat in the Nagaon district, which contains the name of Akhtar Ali, son of Abir, at serial 228, as well as a voters list of 1970, also village Kanchanpur, which again contains the name of Akhtar Ali, son of Abir, at serial 217. Before the tribunal, the petitioner as DW1 had deposed that she is the daughter of Akhtar Ali of the voters list of 1965 and 1970 of village Kanchanpur. And she was married to Inas Ali of village Kanchanpur, and thereafter shifted to village Hatipukhuri and the police station Rupahihat in the Nagaon district. Where does the tribunal get the name Akbar Ali?
Akbar Ali to put Faisal.
It proves that she is the daughter of Akhtar Ali and not Akbar Ali. From where did the tribunal get that name?
My lord, I have submitted the document page
Uh-huh.
one, my lord, page one, I have submitted. In that one, SP had referred the matter to Sub-Inspector Tulisar Soikia, stating that Fuljan Nessa, daughter of, wife of Inus Ali, and son of it is, my lord, it is then Akhtar Ali, but somehow it came to be Akbar Ali, my lord.
The original
It is
document, the
there.
bunch is there, lordship, page 2. The
Page two, my
bunch of
lord.
documents the petitioner has given, page 2, lordship.
This is the first order of the SP, my lord.
The
The-
SP Nagaon to
His,
Akbar Ali. Full stop. The tribunal takes in its order dated 25/10/2017 had taken note of the voters list of 1965 and 1970 containing the name of Akhtar Ali, son of Abir. And as well as the affidavit of the petitioner stating that she is the daughter of Akhtar Ali. But the tribunal deemed it appropriate that an affidavit cannot be treated as evidence. And also took note of its notice that was issued to the petitioner proceeding, which contained that her name of her father is Akbar. Tribunal accordingly arrived at its conclusion that the petitioner is the daughter of Akbar Ali and not Akhtar Ali, as she claims. The entire approach of the tribunal is disturbing. If the petitioner has discharged a burden that she is the daughter of Akhtar Ali by producing certain voters list, and the tribunal had issued the notice to Fuljan Nessa, daughter of Akbar, it cannot mean that the petitioner had failed to discharge the burden of proving her citizenship. Musammat Fuljan Begum, Fuljan Nessa, daughter of Akhtar Ali, of the 1965 and 70 voters list of village Kanchanpara, can never under any circumstance prove that she is the daughter of Akbar Ali. And merely because the tribunal deemed it appropriate to issue the notice to Musammat Fuljan Nessa, daughter of Akbar Ali. It was the inherent duty of the tribunal to introspect and look upon itself as to whom the notice is issued and who is the person before the tribunal. If the notice is intended to Musammat Fuljan Nessa, daughter of Akbar Ali, but it was served upon Fuljan Nessa, daughter of Akhtar Ali, and Fuljan Nessa, daughter of Akhtar Ali is before the tribunal, it was the duty of the tribunal to discharge Fuljan Nessa, wife of Akhtar Ali, from the proceeding and issue notice upon the correct person, namely Fuljan Nessa, wife of Akbar. The aforesaid inconsistent and dichotomic view of the tribunal has to be deprecated. But the unfortunate aspect is that these kind of situations are repeatedly being noticed by this court. The tribunals are strictly directed not to proceed any further with any person if the notice is issued in the name of one person, but served on another person, and compel that other person to prove that she is a citizen by providing documents of the person in whose name the notice is issued. In other words, the tribunals are requiring these persons to do an impossibility which can never be discharged. In course of the proceeding, in the writ proceeding, Mr. B.C. Das, when counsel for the petitioner had fairly stated that she had interacted with the writ petitioner, and from the writ petitioner, it could be found out that she is also a voter of 1971 of village Kanchanpur, where a name appears as Fuljan Bibi, wife of Yunus at serial 1178, and that the petitioner is Fuljan Bibi, wife of Yunus of the 1971 voters list of Kanchanpur. Mr. B.C. Das, upon interaction with the writ petitioner, could also find out that there exists a sale deed dated, what date?
This is my lord, 1980, my lord,
9/10/1980,
80.
80. Perform to purchase and the seller. बराबर seller बता.
Second page,
Perform
page,
seller to आगे लिखे. No.
I'm sorry, my lord, it is not 9, it is 1, my lord.
Sorry,
It is 110, my lord. not
110.
9. It looks like 9.
Mr. Das, barabar these days, these are the sellers or the purchaser, first paragraph.
Yes.
એ તો seller હોય ને purchaser હોય.
Fusion baby is the purchaser,
Sorry,
my lord.
purchaser.
Yes,
Said by which, comma, amongst others, Fuljan Bibi, wife of
initially.
Inos Ali and daughter of Akhtar Ali had purchased certain land. The petitioner seeks to rely upon the sale deed to substantiate that she is also the daughter of Akhtar Ali of village Kanchanpur. We appreciate the effort made by Mr. B.C. Das and counsel that he had gone the extra mile to interact with the petitioner to find out as to what further favorable documents may be available with her. If the petitioner is Fuljan Bibi, daughter of wife of Innas of the 1971 voters list of Kanchanpur, comma, the burden had been discharged there itself that she is a citizen. We do not understand why the lawyer representing the petitioner in the tribunal could not have made that extra effort to find out as to what further documents may be available. In view of the above, matter remanded back to the tribunal to allow the petitioner to rely upon the voters list of 1971 of village Kanchanpur containing the name of Fuljan Bibi, wife of Innas at serial.
Remand back to, sir. Document public.
Yunus at serial 1178. Full stop. To claim that she herself is the person and therefore discharge the burden under section 9. Thus, respondents in the Home Department may make their own verification as to whether Fuljan Bibi, wife of Yunus of at serial 1178 of the voters list of 1971 of village Kanchanpur is the petitioner proceeding herself, or they are two different persons, and accordingly submit a report before the tribunal. Upon doing the needful, tribunal pass a reasoned order and with the participant.
I pray for a copy, lordship has.
Copy of this order to MS Burma for appropriate circulation.
Much obliged, lordship.
This thing,
Remand back to us.
this thing, writing the name, possibly somebody is very casually doing it. Maybe it is daughter of Akhtar Ali only.
And Akbar.
Somebody casually write daughter of Akbar. And then the tribunal go in insisting that you have to prove
Akbar.
as how can that person prove it? If she
Impossible.
is the daughter of Akhtar, impossible. And by requiring a person to do something impossible, you are declaring the person.
And we're forcing them to get wrong documents. That is how the,
That is in a view of contempt also. Against the tribunal. Yeah. And on the other hand, find out the actual ones. Like those we are venturing into, verify school record, verify these certificates,
it is helping.
thoroughly
Lordship,
cross-examine this Gaungure from where you came to know. You will get,
Contents and the
you'll get
better.
more
protection.
resources,
Yes.
better resources with you to oppose these petitions. Yes, thank you.
9, 10 and 11.
Content issue কৰি থৈ দিম নেকি?
Not to mention, not to mention.
এটা single issue কৰি লিখি লৈ যাব। And
Yes, Lord.
next time, informally send the information. If any tribunal proceeds against the wrong person, forcing him to prove that through the identity of the wrong person, you may drop a contempt against that tribunal. It's better they avoid it. Of course, it is prospective, henceforth. We remember the date today. If after today it happens, then we may drop contempt also. It's actually contempt.
Actually, I think in this matter, the police report itself started the
No,
process wrong.
Tribunal can,
after it went to
tribunal
upward.
always have the power to refer, to
Or get it
send back
corrected
the reference
for
that we are
correction.
finding some
discrepancy.
inconsistencies.
Yes,
This is correct.
I think they also don't do this exercise.
Hmm.
Whatever comes. it
Can
gets
you ever
mechanically.
prove
No lordship cannot.
that if I give a notice, not that Verma, daughter of your father's name, but in somebody's name, and then compel you, now you prove.
Impossible task, lordship.
So this is. Yes.
This item number 10 and 11, both are brothers. Both brothers were declared as the foreigner.
We are not interested in brothers.
Well,
We are interested in
these are
individual cases. One by one,
Common
you prove your
judgment,
case.
common judgment, madam.
Let it be, common judgment we set aside. There cannot be common
Yes, yes.
judgment.
Yes,
Let the two brothers be independently decided.
Examined and.
yes. Lordship will find, Lordship page number 39.
One is Gopal, son of Okhil. Other is Santosh, son of Okhil.
Reference or comment.
Now, Mr. Kolita, what material you have to prove your citizen
Lordship will kindly see page number 39.
in respect of Gopal? Page number,
Yes, my lord, 1971 voter list, my lord.
page number 39.
Yes, my lord. Page number 39 type copy, my lord. Page 40 is the vernacular, my lord. Okhil Pal and Jayanti Rani. Okhil Pal is the father, Jayanti Rani is the mother, my lord. Village
71.
Erapalli.
Ekrapalli. Now,
Yes.
how do you show that you are the,
Yes, lordship will now find,
and notice is, to whom the notice is issued?
notice was Gopal Pal and Santosh Pal. both.
Gopal Pal, we understand. The description of Gopal Pal, where is the notice? We have the notice with you.
Notice, Mala, I have not annexed. Mala. LCR has come, perhaps, Mala, that is there.
Okay, let's see here. Ekrapalli.
Erapalli.
Yes. So now,
Lordship will
which
find,
document will show that Gopal is the son of Akhil?
yes, Lordship will find at page 24, Mala. 24 is the voter list of 2011. Where Jayanti Pal, Santosh Pal, Anita Pal and Gopal Pal. Jayanti Pal is the mother, Mala.
Jayantipal Santosh Gopal. Same Ekravali,
Yes, my lord.
Era Kopili or
Era Kopili.
Ekravali.
Era Kopili,
Era Kopili,
Era Kopili.
Ekravali, both are same place.
No, my lord, Era Kopili, lordship will find 7.
No, no,
That is
see
also-
page 39, it is a Ekra, oh no, it is
Era
Era
Kopili,
Kopili.
Era Kopili.
Era
Both are Era Kopili.
ठीक है sir. What do you say? Finish it here or go back? Because notice is also Gopal Paul,
This lordship.
son of Akhil Paul, village Era Kopili.
I think 71
71
was not exhibited before the tribunal lordship.
Did not exhibit.
Yes, my lord, that could not be
We have to
obtained.
go back.
My lord.
Third, Mr. NK
NK Kolita.
NK Kolital and counsel for the petitioner also. have him. The petitioner Gopal Paul, son of Akhil Paul of village Era Kopili, police station Jamuna Mukh, had been referred to the foreigners tribunal number. Where is that opinion gone? Page number,
Page number, my lord, it is 43 judgment, my lord.
for judgment is 43.
Yes.
Had been referred to the foreigners tribunal number 10 Nagaon at Hankardev Nagar Hojai for rendering an opinion as to why as to whether he is a person who entered the state of Assam from the specified territory on or after 5/3/1971, resulting in registration of FT bracket D case number 787/2015. The tribunal rendered an opinion dated 15/9/2017 declaring the petitioner to be a foreigner. Being aggrieved, district petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of village Era Kopili, police station Jomunamuk in the Nagaon district, which contains the name of Akhil Paul, son of Pramod at serial 765, and Jayanti Rani, wife of Akhil at serial 768, and both are shown to be residing in the same house number 10/2. The petitioner also relies upon the voters list of what is the subsequent
My
one?
lord, to 24 page number, my lord.
Page number
24, my lord.
24.
2011.
Also relies upon the voters list of 2011 of village Era Kopili, which contains a name of Jayanti Pal, wife of Akhil, and Gopal at serial 485, and Gopal Pal, son of Akhil Pal at serial Akhil Pal at serial 488, and both are shown to be residing in the same house number 113. As the name of Gopal Pal and Jayanti Pal respectively being the wife of Akhil Pal and son of Akhil Pal appear in the same voters list, and the name of Jayanti Pal and Akhil Pal appears in the voters list of 1971 of the same village Era Kopili. The petitioner claims that the burden under section 9 of the Foreigners Act 1946 had been discharged. In view of the remanded back to the tribunal to allow the petitioner to exhibit the voters list of 1971 as well as 2011 of village Era Kopili. That the petitioner to produce the complete voters list from 1965 to 2011 of village Era Kopili for examination of the tribunal. Respondents in the Home Department may make their examination, but this is not required. The notice itself is like that. As to whether the notice Gopal Paul and Gopal Paul of the 2011 voters list of village are one and the same person, they are first reasoned order. 322 same lichibo, khali case number will be different, Santosh Paul. I think rest will be all the same.
Yes.
7 July.
The tribunal, the tribunal is directed to pass separate opinions in respect, to pass individual opinion in respect of Gopal Pal and not to pass common opinions with any other person, although the other person may be claimed to be their brother.
Item 12,
Separate, yes, I understand.
May please, your lordship.
Yes.
Lordship, the impugned opinion is at page 43.
Fozor Ali, who is the father of Fozor Ali?
impugned opinion is.
So who is the father of Fozur Ali?
Malmut. We have exhibited two voter lists.
Mr. Counsel, who is the father of Fozur Ali and in which page his number appears? Why don't you provide that information?
Yes, your son of Malmuddin,
Son of
Malmuddin.
Malmuddin. Which page his name appears?
It is, initially he was,
Page 12, Lordship, and it should be.
Sorry.
Page 12 and it should be.
this is the voter list of the father of page 65 and 70 voter list.
Page 12. Malmuddin is the father.
Father, yeah. And then your lordship will come to. page
Which
40.
document will show that Fozur Ali is the son of Malmuddin?
Then your lordship, second in 70.
Mr. Counsel, please answer the question. If necessary, we'll hear you
No,
completely.
yes, sir.
Because there is no necessity of hearing so much. Which document or material will show that Fozur Ali is the son of Malmuddin?
First of all, your lordship, we have exhibited the Jamabandi. Jamabandi copy is there.
Lordship may come to page 18, Lordship, both the father and petitioner's name is there.
Jamabandi is there as well as the voter list of 89, where the father and son's relation is given there.
Let's say.
Annexure D. Your Lordship.
What do you do?
This is the voter list of
Lordship
89.
is appearing for the first time before Lordship.
Should he
Because
send,
I have
should he
not
send
dealt
back?
with This matters much, your lordship.
Should he send back?
Send it back, Lordship.
I think this needs some examination.
Yes. it
Heard
is.
Mr. Reed Biswas and counsel for the petitioner also heard. The petitioner Fozur Ali had been referred to the Foreigners Tribunal number 5 at Morrigaon for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number FT bracket D 765/2017 bracket new number corresponding to FTD 1149/2011 bracket old number. Tribunal rendered an opinion dated 29/11/2017 declaring the petitioner to be a foreigner. Being aggrieved, district petition instituted in the writ proceeding, petitioner relies upon the voters list of 1965 of village Panbari police station Dhing in the present Morrigaon district, which contains the name of Malmuddin, son of Kalim at serial 295. Petitioner also relies upon the voters list of 1989 of village Panbari, which contains the name of Fozur Ali, son of Malmuddin at serial 566. Accordingly, the petitioner claims that the burden under section 9 of the Foreigners Act 1946 had been discharged. The petitioner also relies upon the Jamabandi of a plot of land at village.
District Nagaon subdivision, Nagaon
Village,
circle. D.
village. Nagaon is a district, is a huge area. What village? Hmm.
The village is
Panbari.
Panbari.
It's not nice on page 16. Hmm. Page 16.
The certified copy is at page 70.
Dihin लिखा से गाँव नाम लिखा है। गाँव नाम लिखा है।
पूरा हल्के लिखा ही नहीं.
Saibani,
Mr. Biswas, by making an incomplete translation, it almost went against you. Village Panbari is there in the vernacular. You did not write it. Kilikilo.
Panbari.
Panbari, no.
See, after we found out, you did not go on repeating it. When you ask the question, you don't. Okay, anyway. People. Jamabandi of village of a plot of land at village Panbari, which contains the information that by an order of the order in mutation, order dated 4/9/2017 in mutation case number NAG so and so, so and so. Land had been mutated amongst others in the name of Fazar Ali, son of Malmuddin, in place of Malmuddin, which again gives a primacy indication that the petitioner Fazar Ali may be the son of Malmuddin of village Panbari. In view of the above, remand back to complete voters list.
Voters list because
It's a little short.
petitioner's name appears with the father, but mother's name appears nowhere, lordship. So a complete voters list from 65 to,
We'll note that you raise it in the tribunal. We'll note your
Yes.
objection and raise it in the tribunal. The petitioner to produce the complete voters list of village of village Panbari from the year 1965 up to the year 1989,
89 years.
which may also include the name of the mother of the petitioner. It is noticed that in the voters list presented before this court, the mother of the petitioner nowhere appears, and the linkage to the mother would also be equally vital for the petitioner.
The mother name appears,
Lordship,
submission is in the 89, the mother's name is before that. Only the father's name is not there.
Next second. Next second.
Lordship disposed.
I want to take it. We'll have to hear him some more. I think we'll have to hear Mr. Biswas much. Yes. 65, page number. Sorry.
Page 51.
Fifty-one, 50. Mother, Sadar Ali is the father. Okay.
And next page 70.
Hmm.
17.
1770, same village.
Yeah.
Sadar Ali, father. And then who is the petitioner? Zubeda. Which document is it?
Zubeda's name appeared in total list of 1989,
Page number?
page 23. Same village. Husband name.
But husband,
Yes.
how do you know?
My lord, other
How do you know who is
documents-
the father?
And only my lord, here is Kagura's name.
How does the Gangura know?
Here is my lord, also Kagura.
Any other document, school certificate, your marriage document?
I have forgotten.
Sorry,
And let us be reminded
why?
to produce any. further-
You produced that before us. Whatever you want to produce on being remanded back, you produce it here. We'll examine. If it is good, we'll send it back. The petitioner seeks for an adjournment to provide any relevant material which may show that Zubeda Khatun is the daughter of Hadar Ali, of son of Usan of village Bheloguri, as per of the voters list of 1966 and 1970.
Item 15.
The mother of the petitioner is my lord, Hassan Ali Sheikh. The total list of
Page number
34.
34. Hassan Ali Sheikh. Who is the father or grandfather?
This is the father.
Father.
Grandfather is Qasim Ali.
Paul Mora Treaty of Hundred. And which document will show Hasiman is the daughter of this one?
So the Panchayat certificate issued by the village secretary. Page 57.
What evidentiary value does it have?
Should be only my lord,
document that she will produce in the deposition of.
You think of some other document will
My lord, that is the deposition of brother, the name of. the
deposition of brother.
Brother is the
What material will show that that man is a brother?
voter list of 1977 of.
77, page number
Page number 36.
36. Who is the brother?
Brother is my lord.
Syed.
Next. Ul Muhammad Ali Mills. He had deposed me.
Sorry, Ul Muhammad,
Ul Muhammad Ali Mills. Serial number 611.
611.
611.
He is the brother.
Is the
Where is his evidence?
page 25 is available.
Page 25. Yes. Ul Muhammad. Third, Mr. Jet Hamad, learned counsel for the petitioner also. The petitioner Hasiman Bibi had been referred to the Foreigners Tribunal number 10, Dhubri, for rendering an opinion as to whether she is a person who entered the state of Assam from the specified territory on or after 25/3/1971, resulting in registration of case number FT bracket 10/AGM/397/2017, and opinion dated 31/8/2017 had been rendered declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Kaldoba, third part 3, which contains a name of Hassan Ali Sheikh, son of Fazil, at serial 102. Petitioner also relies upon a voters list of 1977 of village Kaldoba part 3, which contains a name of Hassan Ali Fakir, son of Fazil, at serial 607, and that of Ul Muhammad, son of Hassan Ali, at serial 611, and both are shown to be residing in the same house number 223. It is stated that Ul Muhammad Ali, son of Hassan Ali, is the brother of the petitioner, and the petitioner is the daughter of Hassan Ali Fakir, son of Fazil. To substantiate that the petitioner is the daughter of Hassan Ali Fakir, Ul Muhammad Ali, son of Hassan Ali, had deposed before the tribunal as DW, page number 30. 25. Had deposed before the tribunal as DW 2. Where is the examination in chief? Everything affidavit. DW2, evidence on affidavit.
That is not an affidavit, my lord. This is a deposition. my lord. Page number 25.
So it directly came and tribunal.
Yes, my lord.
Where on a question being put by the tribunal, he stated that the petitioner Hasiman Bibi is his elder sister. Full stop. As Ul Muhammad Ali, who has clearly established that he is the son of Hassan Ali, and further, Hassan Ali is a citizen by virtue of his name appearing in the voters list of 1966 of village Kaldoba part 3. Ki bolo sentence to? Sentence pura bono sir. Read the whole sentence. And also having deposed that the petitioner is his elder sister, prima facie the burden under section 9 of the Foreigners Act 1946 had been discharged. In view of the above matter, remanded back to the tribunal to examine the voters list of 1966 and 1977 of village Kaldoba part 3, containing the name of Hassan Ali Sheikh and Ul Muhammad, as well as the evidence rendered by Ul Muhammad that the petitioner is his elder sister, and thereafter pass a reason order. The respondents may make their own verification. Petitioner may also adduce any further evidence. Reason order be passed.
Item 16.
The state may also further cross-examine Ul Muhammad, DW to Ul Muhammad, if so advised.
By order dated 11/5/23, the petitioner was directed to examine whether the petitioner's
Petition
name of
examined
the
whether
believers-
Lokhi Rani Chaudhary, wife of Narayan,
her mother,
and Lokhibala Kormakar, wife of Narayan, of Borpeta Road, of village Sadar Borpeta Road.
we have filed an affidavit today, Lordship, enclosing the documents. In fact, what has happened, her mother, the petitioner's mother's name has, the surname has been wrongly entered as Kormakar in the 1985 voter list. After various, that was her maiden name. That is the petitioner's mother's name.
Mother is originally Kormakar, after
Kormakar,
marriage
after
Chaudhary,
marriage
but in
Chaudhary.
85 entered as Kormakar.
Kormakar.
Okay.
That is the, we have filed an affidavit enclosing documents showing that both are one
Yes,
and the same person.
Mr. Sharma, they go back to tribunal, they'll examine whether it is true or false.
Lordship.
Hmm?
And also, the uncle of the petitioner was also
Madam
examined as-
Borgohain, in these proceedings, there's nothing called father, uncle, brother. First, you have to prove and then only you refer to that
Yes,
evidence.
Lordship.
Because lot of cases are there, people are just brought from the street and projected that he is by so and so. So first you have to prove that what kind of uncle he is. Then you refer to his evidence.
Lordship, if these documents are, we
I
are.
think this is good
allowed-
enough.
Yes,
Because the only difficulty was Lokhibala Kormakar and Lokhi Rani Chaudhary.
Lordship, there is also one more problem. The 85 voter list that was not exhibited.
You go and exhibit.
Yes, that may be permitted. Yes.
We permit you do anything you feel like. Only thing you prove it. That's all.
Lordship, yes, yes. We have enough documents. Only because of that, the council concerned did not apprise the petitioner, these are
What to
the.
do? We already passed a order in the morning. Appreciating one learned counsel for going the extra and finding out lot of material in the High Court. Whereas the counsel in the tribunal could not extract those documents.
All the documents from the husband's after her marriage, those were exhibited. Whereas she had these 85 which they.
But
which-
you have to do it through your father, not through the
Yes, that was the problem, Lordship, the.
third MSD Borgohain and counsel for the petitioner also heard this. The petitioner, Alo Kormakar, had been referred to the foreigners tribunal number
10
10 Borpeta for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 120/2017. An order dated 30/10/2018 had been passed declaring the petitioner to be a foreigner. Being aggrieved, district petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1965 of village Sadar Borpeta town. Which page?
Page 64.
64. Sadar Borpeta town. No, 64 is 85. 29.
Oh.
Of 65 of village Sadar Borpeta town in the Moja Govardhana in the present Borpeta district, which contains the name of Narayan Chaudhary, son of Harish Chandra at serial 142, and that of Lokhi Rani Chaudhary, wife of Narayan at serial 1492, and Lokhi Rani at serial 1493, and both are shown to be residing in the same house number 443. Reliance is also placed on the voters list of 1985 of village Borpeta Road, ward number 8, which contains the name of Lokhibala Kormakar, wife of Narayan, and Alorani Kormakar, daughter of Narayan, respectively at serial 195 and 196, and both are shown to be residing in the same house number 228. It stated that Narayan Chaudhary in the meantime died, but After his death, the name of Lokhi Rani Chaudhary, wife of Narayan, had been entered in the voters list as Lokhi Bala Korpakar, wife of Narayan, by taking the maiden name. Accordingly, the name of her daughter is also stated to be Alo Rani Kormakar. The petitioner claims that Alo Rani Kormakar of the voters list of 1985 is the petitioner herself. As the name of the petitioner appears along with Lokhi Bala Kormakar, whereas Lokhi Bala Kormakar and Lokhi Rani Kormakar of the voters list of 1965 are one and the same person, the petitioner claims that the burden under Section 9 of the Foreigners Act 1946 has been discharged. Full stop. The petitioner has filed an affidavit stating that Lokhi Rani Chaudhary of the 1965 voters list and Lokhi Bala Korpakar of the 1985 voters list are one and the same person. Without going to the question, without arriving at the conclusion, we leave the question open and remand the matter back to the tribunal to examine through any other reliable and cogent evidence as to whether Lokhi Rani Kormakar, Lokhi Rani Chaudhary of the 1965 voters list of Sadar Borpeta Road Town and Lokhi Bala Kormakar of Borpeta Road Ward number 10 are one and the same person, and thereafter pass a written order. Petitioner would also be at liberty to produce any further evidence as may be advised. The respondents through the Home Department may also make their own verification on the factual issue with the Lokhi Rani Chaudhary of the 65 voters list and Lokhi Bala Kormakar of the 1985 voters list are one and the same person. Upon doing the needful, written order be passed.
17.
Yes.
May please, Your Lordships. The petitioner's grandfather name is 66 voter list.
Page number
Page 32, Lordship.
32,
Particular page is 33, Lordship.
33.
In Nosali, Lordship, the grandfather.
Yunus Ali, grandfather,
Grandfather. Misironnesa is grandmother.
a son of Mir Box
Mirbox, Lordship.
and
And the
Miribon Nessa,
Misironnesa
Misiron Nessa.
in Nosali, Lordship.
She is the grandmother.
Grandmother. When
Okay, now who is the father?
70 voter list level,
Page
34,
number.
Lordship.
Page number
34.
34.
Next page, Lordship. The Abdul Barek, Lordship.
Page number 34. Abdul Barek is the father.
Father.
Yunus Ali is
Grandfather.
the grandfather. This is 1970 village.
Village Hazibara. same village.
Hazipara.
Hazibara.
Okay, now which document will show that
The
Sakina Begum is the daughter of
Lordship,
Abdul
page
Barek?
page 51, Lordship.
Page 51.
One Lordship. He appeared in the SLC examination, Lordship. The testimonial certificate, Lordship.
Page 51. Have you examined the headmaster?
The no, Lordship.
Go and examine with the oral student.
And Lordship, the Jamabandi copy is the 80, page number 85, Lordship.
80.
Same village,
85.
85. The middle portion, the Sokro Vikhaya, 20,
25,
05.
2019.
This is the Uttari
Putre
Diputre name
Abdul
is
Barekos Tholor,
Hmm.
Sakina Akhtar Begum. Sakina is the petitioner.
petitioner,
Heard me say your name?
An Ahmed.
And Ahmed, Land Counsel for the petitioner. So the petitioner Sakina Begum had been referred to the Foreigners Tribunal number
Baksha Tamil. Honor.
had been referred to the Foreigners Tribunal Baksa at Tamulpur, Assam for rendering an opinion as to whether she is the person who entered the state of Assam on or after 25/3/1971, resulting in registration of FP case number 2457 stroke Baksa, all capital, stroke 2016. The tribunal rendered an opinion dated 31/2019 declaring the petitioner to be foreigner. Being aggrieved, the state petition is instituted in the writ proceeding. The petitioner relies on the voters list of 1966 of village Hajipara, Moja Ghilajari in the present Borpeta district, which contains the name of Ines Ali, son of Mirbox at serial 1, and that of Miziron Nessa, wife of Ines at serial 2, and both are shown to be residing in the same house number 1. It is claimed that Ines Ali is the grandfather of the petitioner and Miziron Nessa is the grandmother. Further reference is made to the voters list of 1970 of village Hajipara, which contains the name of Ines Ali, son of Mirbox at serial 1, Misiran Nessa, wife of Ines at serial 2, and Abdul Barek, son of Ines at serial 4, and all are again shown to be residing in the same house number 1. It is claimed that Abdul Barek is the father of the petitioner. To substantiate the same, reliance is placed upon a school certificate. Where is it?
And admitted also 69.
Upon a school certificate at a certificate issued by the headmaster in charge of Hajipara High School, which contains the information that Sakina Akhtara is the daughter of Abdur Barek of village Hajipara. Full stop. But you notice that the headmaster of the school had not been examined in view of the law laid down in Sudhir Roy Niki. Sudhir Roy, no, a school certificate. Onima Das. In Onima Das versus Union of India and others reported in so and so, there is a requirement of examining the headmaster with the original school records to establish the contents of a school certificate. Petitioner also relies upon the Jamabadi in respect of a plot of land in village Hajipara, wherein it is provided that as per the order of the circle officer dated 25/2019 in mutation case number BAR/2018-19/46, land had been mutated, amongst others, in the name of Akhtara, Sakina Akhtara, bracket Begum, daughter of Abdul Barek, in place of Abdul Barek. Full stop. The mutation order also may also lead to a conclusion that the petitioner is the daughter of Abdul Barek. We have noticed that the name of Abdul Barek appears in the voters list of 1971 of village Hajipara, which also contains the name of Ines Ali, his father, whose name again appears in the voters list of 1966, also of village Hajipara. In view of the above, we are back to examine the voters list of 66/71 of village Hajipara, and also allow the petitioner to examine the headmaster of Hajipara High School to be present, along with the original admission register of the school, as well as also to take note of the order of the circle officer dated so and pass a reasoned order. The petitioner to produce the complete order of the circle officer dated for examination. The respondent may make their own verification and submit report, reasoned order.
Lordship. Lordship, the Buddha list 1970. There is a 71.
70.
70. My lord.
Item 21 for hearing. No.
His your lordships.
Zero 56 of 20. 3056 of 2018.
Lordship. Lordship, inquiry was made only against the
That
petition.
yesterday's matter.
Yes, yes, Lordship.
What happened yesterday? Just remind me.
Lordship, notice was issued only in the.
Oh, বাকি order to retain করিছে। Notice. Was notice issued to all the 7 petitioners or only to petitioner number 1?
Notice issued all the 7 petitioners, Lordship.
And reference?
Reference was made
And
only
just,
against, what reference
no.
inquiry was made only against the petitioner, Lordship.
Only against the petitioner.
Lordship.
And but a
Notice was issued,
just,
notice also issued.
flag mark the 2 pages. Please flag mark the 2 relevant pages, notice and the inquiry. Why is on? Okay. Wrong, reference upon a night. The inquiry is the reference is only against this one. Baki is set aside and we will be given to the referring authority to make a reference if so advised under the law. Ali kone receive it, what are the signaling? So, me Mantur against my DC Lotan, I think we ended it. She went back. I think otherwise I completed this order.
Yes, Lord. Only because of notice, Lord.
I know.
Yes.
In respect of petitioner number 1, I think we completed the order.
Yes, Lord.
Yesterday, I think for.
Right. Right, could you?
And notice was issued to us, Asikul Islam. Lord.
At least shorten to the written particular কথা নাই নহলে আকৌ এবাৰ শুনিব লগা হ'ব ওলাই যাব নেকি? In respect of petitioners number 227, it is noticed that the inquiry as well as the reference made by the superintendent of police border, which district?
Morrigan.
Morrigaon, was only against the petitioner number 1, namely Atikul Islam,
Petitioner is Atikul Islam.
namely Atikul Islam. But there is neither any inquiry nor any reference against the other 6 writ petitioners. In view of the above, the conclusion arrived in the impugned opinion dated so and so against the petitioner numbers 6 to 7 are also set aside. As there is neither any inquiry nor any reference against said 6 writ petitioners, liberty remains with the Superintendent of Police border, if so advised, to make separate references against the 6 writ petitioners. But the tribunal shall not proceed against the said writs without any separate references being made against each of them. I think this is good enough. Anything more?
Yes, Lordship. Another issue was there, Lordship, regarding petitioner notice was issued to Asikul Islam, Lordship. Petitioner appeared before the tribunal, Lordship, as Atikul Islam alias Asikul Islam, Lordship.
There cannot be any alias. This alias business we are having very
This
difficulty.
was based,
In criminal proceeding, yes, we have lot of alias. Because when one accused is there, somebody will give his name to be so and so. The person will be meant to be also known by another name. You have the business of alias, but the person is same. In these proceedings, where is the scope of any alias? If you feel X is to be proceeded to it, it is X alone. And you proceed against X in the name, in his name as X, even if he is known by some other name. You cannot proceed against him as by some other name. You proceed against him only as X and determine whether X is citizen or he is not citizen. Otherwise, there is a confusion. How can a person ever prove? Suppose we want to proceed against you. You have a definite name. If our proceeding is in the respect of a little variation in the name, how can you prove yourself? You can prove only as Mr. G. Sharma, whatever you have to prove. Suppose we issued a notice as Y. Sharma. Can we ever prove a case of Y. Sharma? This is the difficulty we are having. So we are not taking note of any alias. Tell us the real name of the person, whether he is the person or not. That's all. And that person will prove through documents in respect of that name alone, not in respect of any further names. So let it remain Atikul, because Atikul is the petitioner before the court. And the reference is also made to
Asikul.
Asikul.
father's name is
No, just a minute.
owner.
This is the notice of the tribunal. Where is the reference? It will afford it to the same problem, I think. Inquiry also against Asikul.
Notice and to Asikul Islam.
Then we set aside everything. If our inquiry is against Asikul, notice is also against Asikul. You have served the notice to Atikul, everything is set aside. How can Atikul prove his case as Asikul? Can he ever prove it? You are going to reject it.
He accept the notice not to appear before the tribunal, Lordship.
So if you it will there is a confusion.
Appeared before the tribunal and.
No, no.
father's name is owner
If you serve a notice on a wrong person, if Atikul, after being served notice, has appeared before the tribunal against a notice issued in the name of Asikul, that means it's a case of wrong service of notice. once there is a wrong service of notice by the tribunal, how can Atikul now prove his case to be a citizen as Asikul? Can he prove it? He will prove as Atikul. He will have may have many documents. Will he have, do you expect him to have any document to prove as Asikul?
Yes, Lordship.
Never. He can never prove it. So you are, by serving the notice to the wrong person, you are compelling a person to give false evidence before the tribunal. This is a contempt from that point of view. If the superintendent border had referred against Asikul, tribunal will serve notice only on Asikul. If you find there is nobody called Asikul, but there is a person called Atikul, send back the reference back to the superintendent. That tell us whether you want to proceed against Asikul or you want to proceed against Atikul. Once the SP says, no, I want to proceed against Asikul, you release Atikul. Don't disturb him anymore. If the superintendent of police corrects the reference, says, no, it correct name is Atikul, not Asikul, give a fresh notice to Atikul and ask him to appear. Otherwise we find it's an impossibility, asking an impossibility to be performed. Same example. Suppose today we issue notice to Mr. Y. Sharma. Servitor Mr. G. Sharma. What will Mr. G. Sharma do? Mr. G. Sharma can prove his case either as G. Sharma.
Yes.
If I accept it, it is well and good, but the tribunals are not accepting because G. Sharma could not prove his case as Y. Sharma. He is proving as G. Sharma. Can G. Sharma ever prove his case as Y. Sharma? If you have any method, tell us, we'll accept it. This is the difficulty you are putting these people. Roy to retain A2 It is further noticed that the inquiry report reference to court. Actual reference to put nice one. It is noticed that the superintendent of police border Borigaon, by his memo dated 29/4/2013, had directed SI (B) Navakumar Bhuya to start an inquiry under the Foreigners Tribunal Amendment Order 1985 and submit a report with regard to Asikul Islam, aged about 50 years, son of Mahmud Ali of village Jodibor Gaon. The SIO police accordingly conducted an inquiry. SIO police Namba Bhuya of the border branch Buragaon police station accordingly conducted an inquiry, submitted a report that during the inquiry, the suspect Muhammad Asikul Islam could not produce any valid document that full stop. There also he had written something wrong. Could not produce any valid document staying in India after 25/3/26. It should have been before.
Yes,
Mhm. Right. Valid document staying in India after 25/3. The superintendent of police accordingly by his order dated 29/4/2013 referred the matter to the Foreigners Tribunal for initiating a proceeding under the Foreigners Tribunal Order 1964 in respect of Muhammad Asikul Islam, son of Muhammad Ali of village Joribor Gaon in the Morigaon district. Accordingly, FT case number 65 of 2013 had been registered where an opinion dated, what is the date of the opinion? Where an opinion dated
7/7/2018.
7/7/2018 had been rendered, declaring the Asikul Islam to be a foreigner. Where is the order of that tribunal?
Lordship, page number 56.
56.
Yes, Lordship.
The tribunal rendered an opinion dated 7/2018 declaring the petitioner petitioner. See, Exhibit G is the issue by the Gaumbura, contains state emblem. It cannot be accepted as valid document for improper use of state emblem. This tribunal is proceeding under the violation of National Emblem Act, or he is proceeding under the Foreigners Tribunal. Here, more relevance is the content of the affidavit, not the form of the affidavit. Form of the affidavit, you can always direct the Gaumbura, don't issue this kind of certificates. But can you throw it away? Just the using of the emblem makes the contents of the certificate to be also unacceptable. Accordingly, they declared to be foreigner. The tribunal accordingly issued a notice to Muhammad Asikul Islams and others of village Joribor, police station Bhuragaon in the Morigaon district. And the notice was served on Muhammad Atikul. Accordingly, Muhammad Atikul appeared before the tribunal, sought to discharge the burden under Section 9 of the Foreigners Act 1946 to prove that he is not a citizen. But as notice was issued to Muhammad Atikul and it is Muhammad Atikul who had appeared before the tribunal, it would be reasonable to expect that Muhammad Atikul will prove his citizenship by means of documents in the name of Muhammad Atikul. Whereas on the other hand, it is noticed that the inquiry reference and the notice says are all against Muhammad Asikul of village Joribor. Did you inform the tribunal that you are Atikul and not Asikul?
No,
Did not inform them. The aforesaid inconsistency also remains. If the notice is the inquiry reference and notice is against Muhammad Asikul, but in fact it was served on Muhammad Atikul, and it is Muhammad Atikul who is appeared before the tribunal. We are of the view that there is also a requirement to return back the reference to the Superintendent of Police border for resubmitting a correct reference as to whether the intention is to proceed against Muhammad Asikul of Joribor of village Joribor, or the intention is to proceed against Muhammad Atikul of village Joribor. If the intention is to proceed against Muhammad Atikul, appropriate corrections be made and the notice be issued to Muhammad Atikul so that he can discharge the burden under Section 9. And if the intention is to proceed against Muhammad Asikul of village Joribor, in such event, Muhammad Atikul should be discharged from the proceeding and he be not disturbed any further, and appropriate proceedings and notices be served to Muhammad Asidul. As the matter is remanded back, the aforesaid aspect be also taken note of by the tribunal and do the needful accordingly. If any corrected reference is made against Muhammad Atikul, and notice is also served upon Muhammad Atikul, Muhammad Atikul may continue with the proceeding, may continue and take the proceeding further from the stage as indicated above when the matter had been remanded back.
yes,
If he is not, don't disturb him anymore. If he is yes, new notice, from that stage he'll continue.
yes.
Right?
Applies. Lordship.
Clear.
Time being item 7.
He's on left, Lordship, in code number 12, Lordship.
Adjourn to be listed again also on the inconvenience of the land council for the petitioner.
Yes.
Doctor was here sometime
Yes,
back.
yes, Lordship. Again, he was called
Why did you want him?
in code.
The
number-
president.
Yes, Lordship.
Okay. Ask him to remain present at 2.
Yes, Lordship. Instruction.
I mean, just.
My lord, my colleague say, he says that Lordship instruction is yet to come, Lordship, so. Lordship may fix it at 2, Lordship.
Four weeks time to file affidavit, but we can do, these proceedings cannot wait that long.
That secretary, he is not holding the post of the secretary. So, yes,
Huh. Wherever he is. 4 weeks is too much,
it's 2 weeks.
not 3 weeks.
I'm trying to.
We'll ask him to remain personally present, hear him verbally and discharge him. We did not file affidavit. 29/3, today is 22 months have gone by. And these are proceedings which have been taken at the earliest. These are not regular writ proceedings that months after months you keep on giving time to the respondents. No, not writing. Name of the secretary remain present. Order affidavit next week. One chance. We are putting it either his presence or the affidavit next week. And this is only a simple aspect. We just want to know that you have issued a certificate from where you came to know about the facts. That's all. It's only a one paragraph. No, we don't need not say that. Not 2 weeks. Then what will happen to this person? Yeah, but your secretary is not understanding.
I'm just trying to contact and definitely file.
But he is not available.
He is not holding the postponement.
What's his name?
I'll file it in 2 weeks. Last chance maybe.
Tell that man to respond to the court queries immediately. Because one simple answer we know. He may be knowing, he may not be knowing. If he is knowing this is a good certificate, this man should be discharged at the earliest. Why doesn't he provide that small information? This comes when so for the affidavit of the secretary as ordered by the order 2023. It is provided that even the affidavit is not in place, the secretary to remain present. Did you follow that? Have you understood, Mr. Doctor? Normally, in a writ proceeding, we give you time. This is not even because you have to do a lot of work, go through records, find out records, file affidavit. Here is only one line we want. From where you came to know about the information that so and so is the father of so and so. That's all. And tell him he cannot delay these proceedings.
Item 18 to 20 for admission.
And where is Mr. RKD Chaudhary? Can we have him for just yes. If he cannot come out of that matter, ask him to meet me in the chamber. We just want one or two clarifications from him, that's all. What about the tax factor? And the other one. And right to food, right to all these other things. These are the aspect that whether these people will pay tax or not. So ultimately, the public exchequer, this cost will be one. Yes.
Nothing much to say, just on the National Food Security Act, because already submissions were being
They
made.
say it is not applicable.
If we just go through the act, just the
And I-
introduction of the act, and I'll go to section 9.
NFSA Act কপি ছপিও দিয়া আছিল নেকি তাতে?
May I read, Lordship? Introduction. Eradicating extreme poverty and hunger is one of the goals under the Millennium Development Goals of the United
What are
Nations.
you reading?
From the introduction of the National Food Security Act.
My copy does not contain all those things.
It's from the act.
Okay,
Just
that printed there, act. Okay.
Yes, national.
An act to provide for food and nutritional security in human life cycle approach by ensuring access to adequate quantity of quality food at affordable prices to the people to live a life of dignity.
So in the introduction part, Lordship, it says that it casts responsibility on all state parties to recognize the right of everyone to adequate food.
Everyone means?
Everyone means whoever is here in the territory of,
Where do you get it?
because if we say
Everyone?
as a human being, if
No,
we are
no,
here,
no. As a human being, will NFSA be applicable to anybody in this world? Suppose a man in Somalia says that I am having no food.
then he has to seek for
no,
the procedure and then.
No, understand. Indian government has a act called National Food Security Act, where food is provided to everyone. I'm also included in the everyone.
Lordship,
So is the
then
Indian
he-
government under obligation
It's
to
not-
send food to that man?
in this territory, he has to be.
Where
in
where
the-
is the expression in this territory?
It says that Lordship
Where it-
eradicating extreme poverty. I may be
Poverty.
wrong, Lordship, my, what I understood,
And no,
in
you are
a-
saying everybody,
everyone to educate
So
food,
we
it
have
casts
to
responsibility.
now interpret the expression everyone.
Everyone,
We have
Yes,
to
sir.
interpret the expression everyone now,
yes,
whether everyone will also include a non-citizen.
yes, Lordship.
Mr. Biswas, we will pass that order. Same order.
And then Lordship, I'd like to go on section 9.
No, no, now this right of everyone, it casts eradicating extreme poverty and hunger is one of the goals under the Millennium Development Goals of the United Nations.
Yes,
It
Lordship.
casts responsibility on all state parties to recognize right of everyone to adequate food. This state parties
Yes, Lordship.
means all state parties within the ambit of the United Nations.
So,
Meaning
Yes.
thereby that everyone relates to everybody's own people.
yes, Lordship.
So under this Millennium Development Goal of the United Nations, every state party, the Somalia government is for the people, citizens of Somalia.
Yes, Lordship.
Pakistan government is for the citizens of Pakistan. Indian government is for the citizens of India.
And Lordship,
Just because somebody is illegally coming and staying here, how can they make it an obligation that we should be given everything? Now again, we test it with the principle of Madam Mitra, Article 14. The same thing. If you say this, everyone includes everybody who is has his foot within the territory of this country, irrespective of citizen or non-citizen, means an equal treatment is given to two dissimilar persons. Or the same law is made applicable under dissimilar circumstance, which will violate Article 14 if it is done.
and as per section 9, it coverage of population under the target public distribution system.
Ah.
It says that as per the census, may I read just this provision, then I'll conclude, Lordship.
As per the census.
Yes, Lordship, may I just read
Yeah.
only section 9 of this act? Coverage of population under target public distribution system.
The percentage covered under the targeted public distribution system in rural and urban areas for each state. Here state means the provincial states.
Yes, Lordship.
Shall subject to subsection 2 be determined by the central government. And the total number of persons to be covered in such area shall be on basis of the population estimates. Population is population of the country.
As per
And
the
I don't
census.
think a citizen is included in the population, non-citizen is included in the population of the
As
country.
per the census, so
Huh.
census, these people are counted. let-
This is the whole fallacy. These people have either wrongly or scrupulously got themselves included in the census, where they ought not to have been.
And the act says the
Hmm.
census, so if they are in the census, so they have to be
So
counted, Lordship.
they are in the voters list also. Not only voters list, somebody is maybe an MLA also somewhere. That will not change the situation. Suppose one of this person not
Yes,
only
Lordship.
becomes an MLA tomorrow. Then what will happen? Will it change the situation? That I have become an MLA, so now I mean, that will be everything.
So if they are included in the
If
census,
they are included, they should be ousted by virtue of being the declaration they are non-citizen.
so this. And
Implication of this declaration is they'll be ousted from the census also.
so once they are included in the census, so
Yeah.
and food as in.
So
So it's the
this
responsibility.
is the whole difficulty. Entire concept is by hook or by crook, we have entered. Now we are here. Ultimately, we go back to that
And
theory.
in fact, section
And-
4 also, they are
and that
entitled to
theory-
section 4.
And that theory, by whatever means we have entered, so here we are, is in conformity what the Supreme Court has provided, that this is an aggression. If you look it from the other side, means you are putting a success, stamp of success to the theory of aggression. By whatever means we have entered here, we are here now. Now we cannot do anything. It's
And in fact, section 4, Lordship, section 4 says that nutritional support to pregnant women and lactating mothers. So if a woman is there who is a declared foreigner, so she is entitled,
no, this is again, a pregnant woman is a class within the class of these people to whom the act is applicable. Once the act is applicable, then
Yes, Lordship.
there is a pregnant woman. That pregnant woman is given some
Because-
extra benefit, which is not given to the non-pregnant woman or to the non-women.
so she,
But first and foremost, you have to think it from that point of view. Every word you can't expand it in an unlimited manner.
because in the
But
entire,
otherwise,
yes, Lordship.
right to food is a totally different concept. Minus these statutory provisions. Because we are recognizing the Article 21 right, that you should not be allowed to die in hunger. So, food must be made available. How you procure the food? As long as you live, you buy the food. How will you buy the food?
And
You'll
the-
also be given some limited opportunity of working according to your capability. What would have happened had this family been an Indian citizen and there would not have been all these laws like NFSA, that only people will work by, and what was there about 50 years back? 50 years back, what was there? Every head of the family used to go earn, or other family members support him. The whole family acquires some resources. With that resources, they procure everything, all their needs. So for these families, we'll have to go back to that situation. You work. And they're also agreeing that you'll be allowed to work. Only thing, certain restrictions in certain spheres. Residing also certain restrictions, because they'll have to also indicate where you reside. Reside, stay, work. Get your food.
Suppose a woman is declared as a foreigner, Lordship, and her husband is there, her child is there. So if she is, he is,
And that woman is staying.
yes, Lordship.
Let us see, give it a very good example. And this is, in fact, we are waiting for this question to come. If the woman is declared a foreigner, who has a husband, who has a family, that woman has no worry about shelter and food. She will be disentitled to all other entitlements of a citizen, but food and shelter will be provided by the husband, because the husband is a citizen, he can work, he can earn.
Then Lordship,
And if the burden of running this family is on that woman alone, say all other family members who are citizens are incapable of earning, only that woman will work as per the laws applicable to a foreigner. And
so if she is not, if she is restricted to stay away,
she's not, no one is
So,
restricting.
because then
No one
again,
is
there will be a
restricted.
specific, whatever.
No,
as
no,
per
you are
the-
thinking still confined to detention camps. We are out of detention camps by now.
Yes, Lordship.
Only thing restricted areas, somebody may say, you cannot reside in Kamrup Metro. Don't reside in Kamrup Metro. Go and reside in Kamrup.
So a child and husband will stay in
No.
Kamrup Metro and she has
Your
to
husband
decide.
has to adjust accordingly. There are many working women. We have a number of judicial officers who are working here and there. How they are adjusting their family? Same.
Lordship, for her, suppose her husband's house is there and she in
Madam,
Kamrup Metro, Lordship.
keep this woman, make it equivalent to a woman serving in under the government of Assam.
They are provided with quarters.
Ah. Why? By virtue of their working.
Yes, Lordship.
This woman also, suppose there is a restriction of a particular area in Kamrup Metro.
Yes,
The
Lordship.
husband likes to stay only in that area, does not like to move out. What will happen to this woman? This woman will stay outside that area. How? In the same manner, the working woman stays, work or stay. If the husband is so uncooperative, if the entire family moves to the unrestricted, and this unrestricted area, mind you, come out of your mindset of a detention camp that it will be within four walls of nothing else.
That's understood.
Move freely. You move freely wherever you want to move, except for certain areas where they may impose a restriction.
And Lordship, this act also says another aspect is that women who is the elderly women in that family will be issued with a ration card. Suppose that elderly woman is declared as a foreigner and
Okay, if they-
rest other family members are Indian.
Under very well. It
So
can be easily read to be the next elderly woman of the family.
if there is no other women in that family, in certain circumstances, there is only one
Which
elderly.
provision?
Yes, it says that it will be issued to a women.
Which provision?
Yes, I'll read out that section.
See, Madam Ghosh, wherever is a will, there is a way out. This cannot be the reasons that the entire law will be changed for in respect of a particular category of people.
Is this much only I have to say? I'll just read out that provision. It
which
says it will
provision?
be issued.
That can easily be interpreted.
Previous practice for the persons. Transactions provided. For the previous. Just put it with the National Food Security Act. Unless it's issued to the women.
Mr. Mojumdar. Right to vote have to take out of the voters list. We are arriving at work it out.
List member.
These are the
Main.
two main things they will not be entitled. Plus, central government by order can provide certain restrictions as regards their residence,
Right.
where they can reside and where they cannot reside.
Cannot.
Central government will pass the orders. Beyond that, Madam Mitra had argued on Article 14.
Right.
That applicable. So we have to go a little deeper. What is Article 14 and in what respect it will be applicable? If you are going by a common understanding, right to equality, all are human being, everything, all are equal. That is perhaps not Article 14. Article 14 is equality before the law and equal protection of law. Here again, even in the TMFI, that minority judgment also,
Right.
it has been clarified that equal protection of law amongst the similars.
Yes.
So moment there is a dissimilarity, the law will also be different. Perhaps we'll have to look from that point of view. And within the similars, within the foreigners,
There should not be any dispute.
declare, if you're giving something to somebody and something, not to somebody else,
Then to that
their
extent, 14 may
Article
come.
14
To that extent.
to that extent applicable. 19(1)(g) is not applicable. That the Supreme Court has already held
Very
it.
correct.
Now remains 21.
20.
21 arguments are on right to food. Even we agree with right to food.
Right.
You cannot allow a person to remain, but you won't get to eat.
True.
Right to shelter also perhaps, yes. And otherwise, right to health, definitely.
Right.
Right to health is a thing, if necessary, you'll have to bear the expenditure from the exchequer also. You cannot allow a man to die out of some illness or disease just because you are a foreigner. It will be most improper
Unjust.
to view it from that point of view. Then comes the right to education. Now, when you have your right to food, right to shelter, and right to education, arguments are now raised referring to National Food Security Act, that
Right.
it will be under this act. So under this act, it is the central government which provides for most of the
Schemes.
food securities and schemes.
Right.
To whom it is meant for? Citizens or also non-citizens?
My lord, here I've got one submission. These schemes which we have, because under the NSSI, National Food Security Act, if your lordship, I just make one submission, my lord. I was thinking of making this submission. If your lordship goes to section 10 first.
No. Before we go to section 10, Madam Ghosh
Madam.
goes to the introduction.
Yes. Introduction.
Second sentence, it casts responsibility on all state parties to recognize the right of everyone to adequate food.
What is that? Yes, eradicating extreme poverty and hunger is one of the goals under the Millennium Development Goals of the United Nations. It casts responsibilities on all state parties to recognize the right of everyone to adequate food. Food security means availability of sufficient food grains to meet the domestic demand as well as access at the individual level to adequate quantities of food at affordable prices. Allowed,
Yes, Mr. Mujumdar.
my lord, my submission is like this, my lord. Although in the first sentence
So
it
her
says,
submission is when it is everyone,
Hmm.
it is everyone.
no, my lord, it's not.
Citizen, non-citizen, everybody. I think that is what you are trying to
My
submit.
lord,
That's
yes.
her submission.
Possibly it is not that. When this United Nations, this scheme is concerned, Millennium Development Goal, they did not conceive of a situation that where a foreigner is there in so many, a large number, and then there is always act and law made by the judiciary, also by the legislature and parliament to deport them, to identify and deport them. In that context, a person who will be ultimately declared to be foreigner, for him, this is not the scheme. Well,
We are thinking of another situation. People have come from Bangladesh
Yes, Lord.
over centuries now. Some of them have been accepted. There is a cutoff. Beyond that, you are not accepted.
my lord.
Yes, Lord.
We are dealing with the people beyond the
Beyond-
cutoff who are not accepted.
Yes, Lord.
So they are as good as coming in illegally and staying. If we declare by law that everybody is entitled to the national Indian food security laws, equally applicable tomorrow, if the whole world decides wherever there is nothing to eat, let
go
us
to
march
India.
to India.
Let-
Because there is a judicial pronouncement that
Exactly.
in India there is a law that you will get at least to eat something.
Well, that's what,
Those
And there
people
it does,
are counted in
just a
under the
minute,
Census Act.
just
Lordship.
a minute. There it doesn't matter whether you legally enter or illegally enter. Just enter. Once you enter, they have a system that they'll declare you to be a foreigner. After that, because of some legal complication, they cannot deport you. So we'll be entitled to stay there. Once you stay there, your food is taken care of.
Lordship.
So now we find India is a home of the entire world population now.
Lordship.
Suppose we accept your submission. That will be the implication. There is a judgment by a high court that in India, this is the situation. So tomorrow, wherever in this world there is hunger, I think there are a lot of places. We have already, if you go to the daily, those news and those newspapers, you'll find that
And
it's
other
happening in.
Index of the world shows that India is in the, I think.
So
third
do you mean to say the Mother India is, should open up to that extent? Yes,
Lordship.
Mother India has opened to the extent that it is giving aid in food to many countries. But that is a different situation. The food is given to the people who are still in those own countries. But to make it, for Mother India to make it open that the whole world is now invited to come inside India illegally, stay here, you are assured of food. Mother India will collapse.
My submission is not that, Lordship.
Implication we are asking.
My submission is not that others will come in India and they will have.
No, if you give it to the people who are already in that status, we declare it judicially, it will all, why not it will be applicable and open the gate. Then in future, there's a vast coastline, there's a vast thing, get into the country by some means. Even if you are detected, no problem, because if you enter any other country, detected, your problem. Straight away you are out. Here, that problem is also not there. You cannot be out. Next, you will get your food under the NFSA. How can you test this argument from this point of view? To interpret a national law.
I've got 2-3 more submissions. Let me complete them. Well, the whole idea, although it in the first sentence it says that we want to eradicate poverty, but it all this is in the context of the citizens of India. Then, if we read this, because under
No,
this,
that citizen is being countered by the word everyone.
no, she has said, but then I'm coming to that. I'm coming to that. My lord will kindly see one thing, that if we go to section 10, then 3, then 9, a list has to be prepared of the targeted people. State government or the central government is not required to prepare a list of targeted people of those who have entered India illegally. This speaks because it is in terms of Article 39 of the Constitution of India, which says that the government, state means the country, the central government has a duty towards its citizens, and this duty is to be discharged with the help of the fund raised from the taxpayers.
So this is an act in furtherance of Article
my lord.
39.
Yes, my lord. I'll show, my lord. They have to prepare a list. Central government is not expected to prepare a list of foreigners for giving the benefit of a scheme prepared for the citizens of India in terms of Article 39. And 39 says that from the fund raised from the taxpayers, we have to, now if the taxpayers say tomorrow, we are not going to pay for foreigners, we'll pay for our citizens. That is why I want to take your lordship to section 10 first. How I'll come back to Article 39. The whole Antyodaya scheme is for the purpose of feeding the people of India, not for people of countries outside. In a situation where some country is suffering, we give them aid, is a different thing. There is a different
There can be
situation.
quite a good amount of wheat was sent to Afghanistan.
Yes,
These are
we have given
regular
to Sri Lanka.
transactions.
Now we may give to Pakistan also, but that's a different thing. To bail out a country from a very bad situation. Lords will kindly say, I'm just showing 2-3 provisions, I'll conclude. Section 10 says, state government of this act, my lord, 2013 Act. State government to prepare guidelines and to identify priority households. State government shall, within the number of persons determined under section 9 for rural and urban areas, identify the households to be covered under the Antodaya Anna Yojana to the extent specified under subsection 1 of section 3 in accordance with the guidelines applicable to the said scheme.
So there are two. One is Antodaya Anna Yojana and one is targeted public distribution system.
Yes, my lord. Now,
Whoever is not included in the first,
yes.
they will be in the second.
Yes, now I go further, my lord. The remaining households as priority households to be covered under the targeted public distribution system in accordance with such guidelines again as the state government may specify. Now proviso, my lord. Provided that the state government may, as soon as possible, but within such period, not exceeding 165 days after the commencement of the act, identify the eligible households in accordance with the guidelines framed under this subsection. From here also we can see, now act came in 2013, within a specified period we have to identify. I do not have to identify persons who will regularly come and every time a person comes from there, I again prepare a list. No.
This is a one time.
Yes, one time means of the, that is why I want to say that a reading of the various provisions.
So
of
Madam
this-
Ghosh will be very happy to say, at least give us to that, what's a period? 6 months.
Yes,
To give us within 6 months of that 2013.
yes. But I'm just pointing out the provisions. Now, Lord should kindly see subsection 1 of section 3.
But identify eligible households.
Yes.
Here lies the
Yes, that's why.
issue.
Who is eligible?
So their argument is,
Yeah.
it is absolutely economic situation based eligibility. Somebody doesn't have food to eat,
I possibly.
is eligible. Your submission is eligible household, not only you have, even there's a requirement to provide something to eat, but
Yes.
also a citizen.
Yes. Yes.
So they're disputing that also a citizen
My
by playing onto the word everyone in the introduction.
My lord, I'm.
I think that's your argument, I think.
It should have been only for citizens, like other articles and all, it's mentioned, or it's for citizen, but it's stated that. for everyone.
Where are the articles?
Like, if we see 21, it's no person. That means the main entitlements what a non-foreigner will
Well,
get.
this
will
is what we are
derive
trying
from
to understand. This NFSA Act is not in respect of Article 21.
Yes.
Article 21 is for no person,
Yes, Lordship.
all
Right.
included. So therefore,
And
even
right to
non-citizens.
Food, it's imbibed in
No.
Article 21.
Right to food, yes, but not NFSA. There is a,
Yes, yes. Right to food, yes. I'm also saying that. Right to food, yes.
there's a difference between right to food and right to food in the manner provided in the NFSA. This is where the
Differences.
difference is coming. Right to food, we all agree. And in fact, we have already assured you, we are satisfied with that argument. We are not even questioning that argument. All the further questions is right to food, how it will be channelized. Whether it is through the mechanism of the NFSA or otherwise.
Otherwise.
Suppose a situation in India has come that the markets have absolutely dried out of any food items. I am ready to pay, it is not there. And it is available only through the NFSA, method of NFSA. Then we'll think about it, that you also have to include them. Or we can direct them, give the food through the NFSA channel, but not against this subsidized manner, but against the regular pricing. See, even under the ration card, it depends on the economic condition of the family. A given family may be allotted kerosene at a particular rate, another family may be allotted kerosene in a different way. Why this happened? Because at one point of time, kerosene was a controlled item. You cannot get it in the open market. So there it happened. I think if you go back about 15 years back, kerosene was provided through the ration card system, through the control system. But for given type of family, it was at 3 rupees. For another kind of family, it was 10 or 11 rupees, if I still remember the rate.
Here also much.
Hmm.
Same it's here. There are two categories.
So-
One is the- Under the
So
target.
why that happened? Because at that relevant point of time, kerosene was an absolutely controlled substance in the country. If kerosene is sold openly in the open market, it was prohibited because of that economic situation or the supply situation of kerosene at that point of time. Now it has become open because the supply situation of kerosene has so drastically improved in the country now that regulation is not required anymore.
Otherwise,
In the reverse way, if food is not at all available in the market, then you go into this thing is another factor. But that again, at the higher rate, we are on the subsidized rate. Subsidized rate from where it is coming?
taxpayers.
These are provisions in the for the benefit of the public at large of the country, that for a persons of a certain economic strata or criteria, food will be assured at a much lower rate. That food is not cheap. The food that is provided has its own market value. It is only the government that is providing to the people at a much lower rate, means the balance of the money is being paid by the government from the public exchequer. Like few days back, you had subsidy in LPG. If LPG cylinder was costing 100, it was given to the people at 300 rupees. Balance 700 was paid by the government. It's not that the value of LPG was 300 at that point of time. Similarly, it's with these acts. So now, once these are subsidized by the taxpayers' money, and this category of people will not pay tax. That's why we wanted, Mr. RKD, a little clarification on this issue we wanted.
My lord will allow me to read one paragraph from this statement of object and Article 47. Everything will be clear. Just Lordship will give me 1 minute. Statement of objects and reasons of this 2013 Act. Article 47 of the Constitution inter alia provides that the state shall regard the raising of the level of nutrition and the standard of living of its people, means people of not other country, its people, and the improvement of public health as among its primary duties. The Universal Declaration of Human Rights and International Covenant on Economic, Social, and Cultural Rights, to which India is a signatory, also cast responsibilities on all state parties to recognize the right of everyone to adequate food. This everyone means citizen of India. I'm coming to that, madam. Eradicating
This
extreme
is what
poverty.
Madam Ghosh is saying, everyone means everyone.
My lord, everyone.
Where do you,
No, for
where
ev-
do
my
where
lord,
do you import
my lord,
the?
for the meaning of everyone, we'll have to go to Article 47. I'll go just, Lordship will give me 1 minute. Next sentence. Eradicating extreme poverty and hunger is one of the goals under the Millennium Development Goals of the United Nations. This was the first. This was the first sentence. And last line, again, I'm reading, my lord. Eradicating extreme poverty and hunger is one of the goals under the Millennium Development Goals of the United Nations. This was the first sentence in this book, my lord. Now, let's go to Article 47. This people, everyone means what? This is there in Article 47, madam.
Whatever is circumscribed. as
Yes,
47.
yes, madam. Lordship, kindly see Article 47. Yes, does the Lordship got, madam?
Duty of
47.
the state.
Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people. Madam. Who are they?
People of the state.
Yes, madam. Its people and the improvement of public health as among its primary duties, and in particular, the state shall endeavor to bring about prohibition of the consumption except for medical purposes of intoxicating drinks and of drugs which are injurious to health. It is in terms of Article 47, and it is for the purpose of implementing Article 47 that this act has been introduced.
So
enacted.
everyone read in the context of
Yes,
47.
madam. That makes it very clear that this Millennium Development Goals of the United Nations says you have to look after the poor people of your people. It's your citizens are the citizens of India, my lord. Their care has to be taken by the central government. It doesn't say that person coming from Myanmar tomorrow will say, see, this act is there. Kindly include me in the list. List will be prepared by the central government. There are three stages. Section 10, then section 3, and then section 9. The state government and its agencies have been given the responsibility of preparing a list.
No, according to your submission, this NFSA Act is an act which is enacted by the parliament
My lord.
in furtherance of Article 47.
Absolutely.
So whosoever is made eligible under Article 47, only in respect of those category of people,
Yes.
this NFSA is applicable.
Yes.
This is what
Yeah.
your submission.
Its people, it's very clear. Foreigners are not our people, man. We'll give them food for survival, that is another thing, but not in terms of this act, which is prepared on the basis of the duty of the government under Article 47.
But Article 14 possibly will also be applicable.
My lord.
Suppose this category of people,
Right.
while staying in this country, are coming forward to participate in the labor market. Suppose today they work as a daily wage labor. So the prescribed wage for that labor will be applicable. There, I think Article 14 will be there. For this category of people, you cannot say, are you a citizen? If you're a citizen, I'm paying you 650, the regular rate.
Possibly.
If you're non-citizen, I'm going to pay you 450.
Unless when there is a separate scheme altogether.
The scheme is different.
If
Scheme
why-
is always different because it will depend on the validity of the scheme.
that's what
But
I'm saying. Supposing for this category of
Say-
people,
Today, as a private employer, employing one daily labor for 1 day.
my-
The man comes in the morning to me. I put him the question, you are a citizen or you are a non-citizen?
that will be too
He
much.
could not prove the citizen. I cannot tell him that now I am going to pay you 450, not the regular 650 wage.
Possible.
But if another man comes, no, I am a citizen, okay, you come, I'll pay you 650. Possibly here, Article 14 to some extent may be
Maybe,
applicable.
maybe, yes,
Here you cannot distinguish
possibly. Yes.
because ultimately the similarity and dissimilarity is not whether you're a citizen or not on the quantity and quality of work that you will be doing,
Yes.
putting it ahead.
That possibly I have to.
So let them work. 650 a day is a very good amount. If you earn 650 a day, that comes to 21,000 a month.
Then
That will be the salary of the monthly salary of many of the citizens who are working in the government sector also.
covered under the NFSA. NFSA's criteria is that income
So-
is 1 lakh.
So now we cannot encourage this kind of people. We are going to, we are outsider, we are foreigner, we illegally came in, we'll stay here. We'll also not work. Even the head of the family is also no, we are simply going to sit at home Food will automatically come to us from NMSA. This not. Here possibly the question of human rights will not be applicable
You can.
because you yourself are behaving like it. But on the other hand, suppose the entire family is so sick, all of them are bedridden. Suppose you visualize a scene, all of them are bedridden, no one can work. Maybe, Mr. Mojumdar, this will be a specific special circumstance only for that particular family, not in general.
Yes.
And the government of India is not that draconian that they will allow you to die without hunger, because
Yes.
every member of the family is so sick that they are unable to even come out to do the minimum of work. Then you have to prove it separately.
In fact, if they are engaged as workers also, just an example, Lordship.
So now,
a person-
now in the guise of citizens, when you are staying in this country, what are you doing? Let us have that answer from you.
I didn't get-
These getting people who are likely to be declared to be non-citizens, as long as they are staying here in the guise of a citizen, rightly or wrongly, what work are you doing?
Most of these people are daily wage earner or domestic helper, Lordship.
Continue. Who is stopping you?
There is one judgment of Rajasthan High Court, Himachal Pradesh, where ration cards granted to Nepal, citizens of Nepal were cancelled. In that context, the High Court judgment says, this stand,
This is challenged before the apex court.
no,
Lordship.
till now it is possibly there. The stand of the government of India is that the grant of ration cards implies transfer of resources in the form of subsidies from the government of India to the citizens of India and not to citizens of another country. The fact that there is peace and friendship treaty arrived at between Nepal and India.
Oh, Mr. Mojumdar, we'll not go into that.
My-
We'll go into the argument of Mr. Mojumdar, as the argument placed before this court is NFSA.
An article for
His article is NFSA is
its people.
is rooted to Article 47. Article 47 does not permit.
Mali.
Means we are not going into any political statement like what Himachal attempted. We'll,
These people, my only submission will be, these people are counted in the census. And the coverage which says section 9.
so now you should be criminally prosecuted for entering yourself in the census. If you raise too much of a census issue, we'll direct criminal prosecution against these people for falsely giving their identity and entering in the census. They should have been fair enough to the census man. Please don't include us. We are from foreigner. We are illegally here. So, meaning thereby that they were not fair enough. They had committed a fraud on the census people and got themselves included. So now can you be the beneficiary of a fraud that was initially created?
And
So you better not go.
That doesn't distinguish between, is the reason 1951 census is not counted while proving the citizenship when we submit that, because it doesn't. distinguish
Definitely.
as far
So
as-
now what you are relying on? Census, where do you get that word, census?
Section 9, Lordship.
If the act is not applicable, Mr. Majumdar had clearly made an argument, he had to counter it that as this track is traceable to Article 14, Article 47, Article 47 is only for the state, for its people. The census also has to be read, people of the state. Hmm.
I have written argument, Lordship, and this I can submit that written argument, Lordship.
You call it that to be little.
It's a written submission.
No, you said a little submission.
Not only of me and
That's
Amar.
true. Now we'll take note of everything. We'll do one thing, we'll list it again in the first week of June.
Yes,
Let us go through all the materials that have been submitted. If we have any query, any question, we'll
Yes.
hear you specifically on that. And if we don't, we'll proceed with
Yes.
whatever conclusion we can arrive at, taking note of everything. So it's been a long time. Written submission, Arupani, you say? Mr. Mojumdar, from your side, no written argument.
No,
We are not insisting, means you are not given.
I
Mojumdar, come back. But Mr. Mojumdar, food,
am.
shelter, health,
Minimum things required for living.
education, health, we are expanding to some extent. If necessary, you'll have to also involve the state machinery. There is a public health center in some location. These people are there. A man is sick. The public health center cannot refuse.
Right.
And this will follow from the principle of your guidelines of your own health department, that even the private hospital cannot refuse an emergency patient. You have to give free treatment. I think that some kind of a guideline is there, health guideline. Education,
Yes, some public health. That.
yes, wherever education is available nearby, they will go there. Get educated.
Yes, 6 to 14
Yeah,
only.
get educated properly, become an asset for the country. Make an application for citizenship, showing that I have already become an asset for the country for this reason, this citizenship. I think there is a provision under the Citizenship Act somewhere. That category of people, they can make an application. Join the mainstream. Take the education, work well, the whole family,
Yes,
really work, that even the minimum wages is a good amount of money in this country. Have your basic education, go for the higher education, become an asset for the country. Let that man make an application, they consider it, that only he alone should be considered as a citizen now. And these four will take care. Anything more?
no launch,
Hmm.
no launch.
But how do you assure the availability of right to food? How do you assure? Because right to food is there, you have to give them. If NFSA is out,
If they work, they can themselves, in terms of the act, we see that they can arrange. If they are allowed to work, then they'll be.
so
able to
work is the answer to everything.
possible. Because if they work,
And factually, your statement is that most of these people are working as daily wage laborers,
Yes, Lordship.
nothing beyond that.
Yeah, most of the people, they are daily wage earners. Because there are few DB cases of the people who are working, who got transferred. Because, and they have the documents,
Transferred means
transferred from one place to another, so they have not transferred their
shifting.
shifting. So they have not transferred their vote from one place to another. So with that, they can easily prove their citizenship. Most of the people are government servant or in the private
So
company.
government
So the-
servant also by itself will not make you a.
Not
citizen.
make, but they have the documents. They have the
Doc-
proper
ah.
documentation.
Then it's
So
a
they
different
can
matter.
prove. So there are few, but FT cases, if we see, and most of the declared foreigners are from the marginalized sections. Where to keep their
Now,
documents also
Mr.
is
Majumdar,
difficult.
what have you done for eradicating this problem in a serious and comprehensive manner? it is superficial, or the effort is
Well, as far as
sincere and comprehensive. We'd like the state to file an affidavit.
and that's what initially I said.
No, we'd like the state to file an affidavit to Chief Secretary,
Fine.
whether the effort has been comprehensive, substantial, effective, or it is superficial. If it is comprehensive, substantiate it. If it is superficial, what steps you are going to take?
Well, that is what I said by just referring to the judgment of Karnataka, because this situation of releasing them or taking them out of the detention center.
No, releasing, we are not here.
No,
Reporting also, it's
no,
for the central government to take
no,
up. We are not
I'm
touching that
I'm
issue.
not saying that. What I'm saying is, my lord, that releasing them in bulk from the detention after they have completed
From the-
3 years, from 2 years as per the Supreme Court judgment. This situation has come very recently.
Understand?
After that,
No,
let them take a call, that's what I was thinking. What
no, we
they-
are not on detention.
No, I'm not saying, what do they do?
What will happen after detention is the problem with the central government. They have to frame orders. We are going to direct them. Because they have to put in where restrictions are there as regard residents. And what kind of restriction they may impose on what nature of work you can and cannot do. That is for the central government to, we'll ask them, we'd like to have an order issued under section 3.
Yes.
But we are asking
I know.
the effort that has been made, whether it is substantial and comprehensive to eradicate the problem and go to the root of the problem, or it is more in the nature of a superficial effort being given. One affidavit on that.
Let the central government come up with an affidavit, because they will have to. frame
No,
a
it's the
scheme.
state government.
Then you also, Lordship can direct them to file an affidavit, first. It would have been better.
Otherwise, why we are making all these exercises?
Fine.
If you are only superficial, there are only a handful. If by your conduct,
Clear.
you are allowing everybody to enjoy, why discriminate between a few handful? Who happen to be unlucky that they were referred.
This will be, to some extent, administrative, to some extent, political decision. Let the chief
So,
secretary file an
let
affidavit,
the chief secretary file an affidavit.
let them take the call. But then Lordship may kindly pass a specific order so that they understand, because so much of deliberations have taken place inside the court, they may not be knowing in what direction.
Affidavit be open. So otherwise, why we are saying our entire report will be futile?
Madam,
If just a few handful of people, it will be applicable to 100. How many writ petitions are pending on this? Sorry, on
Maybe
this
Lordship.
issue, how many writ petitions are pending before the High Court?
Declared foreigner will be many, Lordship.
No,
I
no.
myself,
How many writ petitions are pending? We understand that that is the figure of the declared foreigners. Suppose we dismiss every writ petition also, they will be the only number of foreigners.
for whom this.
Huh.
they
exercise.
have not yet.
So for
approved.
that, why do we make such a huge effort to determine their rights? When everybody is otherwise enjoying their rights like anything.
But then, well, today the number is less, tomorrow the number, if the tribunal is determining.
So for, with concern for tomorrow, we require this
Yeah,
affidavit.
that is what I'm saying. So keeping in view the future situation.
And with a definite action to be taken plan, how we were going to address this issue in a more comprehensive and effective manner.
Or my lord, there is, I'm just thinking aloud. Lordship may indicate the contours after all this,
That will be the order will be put in the record room where it will remain forever.
or let them come up with an affidavit.
If we do that, we have passed many orders whose final destination is the record room. This will be another one such order.
Let them think over it and come up with an affidavit.
both Mr. D. Mojumdar, learned additional advocate, senior advocate, additional advocate general for the state of Assam, as well as MS D. Ghosh for the writ petitioner proceedings.
Michael, Session, Michael.
Learned amicus, as well as Baki naam kitaw di dibo. On behalf of the writ petitioner proceedings, have almost completed their arguments on the issue as to what legal rights and entitlements would remain with the persons who are declared to be foreigners post 25/3/1971, and what rights will such category of people be not entitled. But we have noticed that most of the declared persons who have been declared to be foreigners by the tribunals have approached this court by your writ petitions, and the number appears to be not a very large number. In other words, in the event, only such people will be governed by our order as regards what rights and entitlements they would be entitled. But considering the judicial notice that can be taken as flows from the various judgments of the Supreme Court as well as many other sources, further question may remain on the effectiveness of the determination of such rights and liberties as to whether the state of Assam as well as the government of India through its machinery had made any effective, comprehensive and complete endeavor to make a detection of the foreigners that may be present in the state. The Chief Secretary to the Government of Assam as well as the Home Secretary to the Government of India is directed to file their respective affidavits on the said issue, specifically averring as to whether the steps that have been already taken is complete, comprehensive and effective, or much more remains to be done on the issue. If it is not complete, comprehensive and effective, what further action taken plan is being envisaged by the respective governments? The affidavits be put on record before the next returnable date, list on 1st week of June.
8/6.
Will determine the rights.
Right.
But whether it will be a futile determination or it will be ineffective, we want to also know that.
Possibly a slightly longer time will be required because till the time because they themselves will have to take some decision. It's not something.
Let us have it on 8 first, then think about what further to do. Because we have in a concluded judgment, we are required to do this. In doing so, both the governments may also take note of the number of non-cadastral cadastral villages that are available in the state of Assam, whose existence came on or after 25/3/1971, as well as the number of revenue villages that may have increased during this period from what it stood prior to 25/3/1971, and under what circumstance the new revenue villages came into existence, and who are the peoples, which are the villages, and who are the people who are in occupation of such villages. So, Mojumdar, I think,
copy of the.
Copy of the order to Mr. G. Sharma, then counsel assisting Mr. G. Mazumdar, as well as to Mr. R.K.B. Chaudhary, learned BYSDF. But the other part will again require some mail legal order. What do we do with this judgment? Should we deliver it on the rights? That we have already heard. Whichever way we deal it with.
Right. I was thinking.
Ultimately, whole thing will become futile. Why did we hear it for such a long time then? Whatever affidavit you file before it. If you need something more to be filed, we'll give you time. But something let it come up by it.
Let them come up with what idea they have for this situation.
Firstly, whether you sincerely feel it is complete comprehensive or it is not. If you feel comprehensive, put an end to this matter. Don't do anything more. And if you feel it is not what is required to be done, put it. We'll just record it.
My subject to what your lordships think. Personally, I feel that if some contour is given, possibly it will help them and they will
No,
be.
once your affidavit comes, we don't mind giving control, but we can't give it on our own. We can't take
Alright.
over the administration.
Let them take it.
This information we want to know on the effectiveness of our order. Why were we deciding all these rights? If crores of people are allowed to retain their rights, few 1 or 2,000 unlucky ones have
Would
been
have been
detected.
cleared. Considering the number.
Huh.
they appear-
Why don't you give them also everything?
All right, let
If
them-
your decision is not to do anything, give them also, don't do it.
all right,
If you feel the country will be better off that way.
Let them file the.
This will be effective only when a good comprehensive action is taken on this issue. Otherwise, these are ineffective judgments. Only on paper.
Let them file the.
For that, we collected the number of those revenue villages also. It's already with us. Go through it. It appears there is substantial increase in the number of villages. From where? Maybe because of the reorganization, one village is now split into 2 villages. So the number increases. That is also possible. There's a possibility of the government deliberately creating some new revenue villages. There's also a possibility that
Actual increase in the.
under earlier 2 circumstances, government will have the data with them. Who are the people who are inhabitant of these villages, increased number of villages? If you don't have, that's a serious concern.
Let them file the.
File an affidavit, let us see. Whatever you file, we'll keep it on record then. We are not expanding our scope. We are only that to judge the effectiveness of our order. We just want to put it on record what is been done. 8 June.